Okay. All right. Call to order the meeting of the Davidson County Election Commission dated April 17th, 2020. We are starting a little late. It's about 1:10, 1:15, and we are at the Sunny West building at the Metro Howard complex. I would remind everybody about the mask mandate. I would warn you, it is possible that an officer will ask you to leave if you don't put on a mask. I know because there is a Metro requirement for that. We do have masks. If anybody doesn't have one, they are available. Welcome to everyone. As the first item of business is to consider the minutes from the April 6th and April 8th meetings of the Election Commission. Do all the commissioners have a draft of that in their packets? Just please let me know if there are any suggested changes. And in the alternative, just let the chair know when and if we are ready to make a motion as to those two sets of minutes. Commissioners, are there any suggested changes to the April 6th minutes?
I make a motion to approve.
All right, we have a motion. Do we have a second?
I second.
We have a motion and a second. All in favor say aye.
Aye.
Any opposed? The minutes pass unanimously. Please, let's turn to the April 8th minutes.
I'd like to make a motion to accept the April 8th minutes.
All right, we have a motion. Do we have a second? Does anybody need any more time, or are we ready to call the question?
Second.
All right, we have a motion and we have a second. All in favor say aye.
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 Any opposition? With no opposition, the motion carries. The next item on our agenda is the presentation by Professor Blumstein. What I anticipate, or what I would suggest for the Commission's consideration, is that we hear from Professor Blumstein and let him present his opinion, which we received yesterday in writing, and then we allot a certain amount of time for Mr. Cooper of Metro Legal and Mr. Roberts of the For Good Government group. I suggested, and I think we told them, that we would give them 5 minutes, subject to the Commission's wishes on that. And then we would be able, I believe, to ask each of those 2 questions. At that point, we would either vote or not vote, or to decide to vote. And the public comment is slated to occur towards the end of the meeting. Is that satisfactory?
In the past, haven't we allowed public comment on something we're going to be voting on prior to the vote?
We certainly can. I don't have any problem with that.
I think I'd like to hear
Sure.
from the public before we vote.
Okay.
So we can take their,
Sure.
their input in. I don't know at which point you'd like to do it. Maybe the presentations first and then public comment, or
Right?
I'll leave it to the discretion of the body.
Okay. And then we might want to ask Professor Blumstein some questions after everyone speaks, but that again would be at the pleasure of the commission.
That sounds good.
Okay. All right. Does everybody understand that in the audience? If you have signed up to speak, you'll be allowed to speak before we take a vote, but your time is limited to 1 minute. There are some parties that like Metro Legal, Professor Blumstein, and Mr. Roberts of the For Good Government Group that we've allotted 5 minutes. Okay. With that, I'd like to introduce Professor Blumstein. He was selected by unanimous vote of the commission at a recent meeting to provide his views. He has been a Vanderbilt law professor for 51 years. He's a prominent election law scholar. He's argued 3 cases before the United States Supreme Court, and he's one of only 8 professors, university professors at Vanderbilt Law School. At Vanderbilt University. He's been a professor at Vanderbilt Law School, as I said, for 52 years, and he is only one of 8 professors of the university as a whole. So with that, Professor Blumstein, could you explain to us the opinion that you gave us yesterday in writing? And thank you for being here.
Is this mic hot? Okay. Because if not, I'll have to speak a little louder, but it's nice if this is on. Can I be heard by the members?
Yes, please.
By the persons? Okay, good, thank you. Thank you for, am I not doing something right?
No, let's see if we can turn it.
Could be the volume.
Try that.
There you
Okay.
go. Okay.
Is this a little bit better? Yes, I can hear. I can often hear myself think, but I definitely want to be able to hear myself speak. I appreciate the introduction. At a university, we're not accustomed to being introduced in a full way, and so I appreciate that. But the way I often like to say it is, you know, there's a difference between an epitaph and an affidavit, and so I appreciate the nice words and comments of the chair. I also like to welcome the chair, whom I've known for many years, Mr. Starling, whom I've known for many years and through the Leadership Nashville program, and Ms. Hertzfeld, Tricia Hertzfeld, who when she was practicing law, I remember her coming into my office once upon a time when we didn't have the pandemic, and we talked about a case that she was working on, and I would like to think that I provided some assistance to her in her work, and I have followed her career with pride and recognition. And Mr. Evans, whom I just have met this morning, and Mr. Davis, whom I've also just met this morning, welcome to your new duties on the commission. And I appreciate the unanimity of asking me to serve in this role by all members of the commission. And I take seriously the idea that I represent no particular member or members of the commission, but all the members of the commission. I want to say that when Mr. Delanis, the chair, talked to me about this. He made it clear, and I made it clear that the scope of my engagement was limited. It was important, but limited. Limited to the question of the number of signatures on the ballot that were required in order to move the petition forward for the amendment of the charter. And so the question is really, what is the election that we should use as a reference point for determining the requirement in the Metro Charter that there be 10% of registered voters signing the petition? So you have to have 10% of what? And so the question is, what election do we use as the point of reference? I'd like to start first by saying that when Mr. Delanis asked me to review this, I've reviewed the material in his email. But since then, on, I guess it was Thursday, I received a letter from the lawyer for good government, Mr. Roberts, and I just wanted to disclose that. I had pretty well finished my work, although until you turn something in, those of you who are lawyers or who do proposal writing or whatever know that until it gets out of your hand, it's never completely finished. You're always making sure that the I's are dotted and the T's are crossed and that the comma is in the right place and something is said in just the right way. So I did tweak it a little bit, but it had basically been drafted before I received Mr. Roberts' material, and except for the letter itself, all the other material is in the public domain, in the public record. So, but I wanted to disclose that, and if you want me to share the letter that I received, I'll be glad to do that. But the materials, as I said, are materials that are in the public domain. So I also should start by saying, you know, whenever lawyers get into these things, you have to get into the weeds a little bit in order to do the legal analysis. And so to the extent that anyone fell asleep while they were reading my memorandum, I will apologize for that. But it's necessary to go through the reasoning and the thought process. What I plan to do today is to just take a thumbnail, take you through the highlights and the high points of the issues and my conclusion based upon my analysis. Here's the thumbnail, that the Metro Charter provides for a referendum if a petition is signed by 10% of the registered voters in the preceding general election. And so the question that I was asked to address is, what is the preceding general election that counts here? And this becomes important because there is a large difference in the number of votes that occurred in the November 20 election and the August 20 election. And although I'm not in charge of verifying this, I can say I've been informed, and part of this is from Mr. Cooper's memorandum and just from my conversations with the chair, that if the referent point is the November 2020 election, then the signatures fall short, and therefore the commission would not be in a position to put the proposed charter amendments on the ballot. If the proper election, the preceding general election, is considered to be the August 2020 election, then, although this now is more in dispute than I'd understood before, but at least there's a strong argument that the number of signatures have been reached. That's not within the scope of my engagement at this point, but I have become aware of that issue. But that's not the one that's the primary focus of my analysis. First, under the Tennessee cases, starting with a case called the Wise case, in order to qualify under the Metro Charter, an election must be targeted at municipal offices. An election that's targeted at state or federal offices does not qualify as the preceding general election. The Wise case holds that. My memorandum goes through that. That case is a 1983 case, but it's still the law and was reaffirmed in 2018 in a case called the Wallace case involving Ludi Wallace, where the court reaffirmed that, and in a subsequent case, the Court of Appeals has reaffirmed that. So I think Metro, in its submission with Director Cooper, don't seem to agree with the reasoning in the Wise case, but that is the controlling law in the state of Tennessee, and every case can be subject to reevaluation, but that is the law of the state, and I would think that that's binding on the commission at the present time. So it's fine to disagree with the law. I've been known to do that too, but ultimately the commission is bound by the court's determination, not the criticism. So then the next question is, what is the correct preceding election? It's a general election. This cannot be a special election, but it needs to be a general election. And the Court of Appeals in the Fraternal Order of Police case ruled that. And so I think quite clearly the August 2020 election would qualify as a general election that focuses upon municipal offices. And so that clearly qualifies, and I think Metro's memorandum, Director Cooper's memorandum, basically takes that position, and I agree with that, that if that's the right election, then that election does qualify as a general municipal election, and it satisfies the Wise and Wise standard. So then the question becomes, what about the November 2020 election? Does that qualify? Does that stand as the right election to think about? And on its face, the answer is no, because it dealt with federal and state elections, and Wise specifically said you must focus upon municipal elections, not state and federal elections. So I think on its own, the answer to the question whether the November 2020 election qualifies under the Metro Charter provision, the answer is no. So the next question is that election to be deemed a municipal general election, even though it deals almost entirely with state and federal offices? And here, the complication is that there was an election to fill an unexpired term on the school board. And so the position that Justice Koch, Dean Koch, has taken and that Director Cooper has taken is that the school board election is, in fact, a general election, and it has the effect of transforming the entire November 2020 election from an election involving state and federal offices into an election that addresses municipal offices. Upon analysis, I must say I don't agree with that position, and I don't agree with that position for two important reasons. First, I think, and I don't want to, I'll get into this in question and answer, but I don't want to get through all the details. But my conclusion is that school board election to fill an unexpired term is, in fact, not a general election, but is a special election. It's a special election that occurred at the same time in conjunction with, in coincidence with, a general election. But that doesn't change the character of the election. When there's an election to fill an unexpired term, the character, the nature of that election is a special election, not a general election. The timing is one of economy, convenience, and so forth. And if you want to think about it, just think of the recent Georgia U.S. Senate elections. There were two. One was an election to fill, basically determine whether Senator Perdue would be reelected or whether his opponent, Mr. Ossoff, would be elected. That was a general election, no doubt about it, and Mr. Ossoff won that election in a runoff and is serving a 6-year term. There was a second election at the same time where Senator Loeffler had been appointed by the governor of Georgia under the Georgia law, but she had to stand for election, and her election was a special election to fill the unexpired term. It occurred simultaneously with and at the same time on the same ballot as the Perdue election, as the general election, but it was quite clearly understood as a special election. So it's the nature of the election, in my judgment, that controls, not the timing of the election. You can have, and the Tennessee Supreme Court has held in the Wallace case, that you can have, and the Tennessee statutes provide for this, you can have an election simultaneously on the same ballot that's a special election along with a general election. But the key to determine whether it's a special election turns upon the question of the nature of the election. And the nature of that filling an unexpired term on the school board is that it is a special election. Even if I'm not right about that, the question then is, can the school board election on its own transform the entire election into a municipal general election as required under the Wise case? And my answer to that is also no. That the character, the nature, the structure of the November 2020 election is that it is a general election for state and federal office. There is one election for a school board office, but it is not a scheduled election. It's not a regular election. In my judgment, has the characteristics of a special election. And it is an election that is really on the ballot by happenstance. It only occurs when there's a vacancy to be filled, and it's not part of a general scheduled election. Also, the nature of the office that's involved, the school board election, is different from what was going on in the FOP case, where there was on the ballot a general countywide election for a tax assessor, and the court in that case held that that was a municipal election. But here, the character of that election in November is state and federal, and I don't think adding on this one type of office in what is in nature a special election can transform what is really an election for state and federal offices into the kind of municipal election that the Wise case required. So as a result, I conclude that the relevant election, the referent election, is the August 2020 election, not the November 2020 election. And then the question becomes whether the petitions satisfy the number of signatures required. I was told that the answer to that was yes, but apparently that's now in dispute. I'll be glad to respond to some questions about that, but that's beyond the scope of my retention in this matter at this point. So that all that I'm saying in conclusion is that I think that the commission has enough to go forward on this numbers on the ballot, or what we've been calling the numerosity requirement. Doesn't need to go and really defer. I think it has an obligation to decide this. It may be legally authorized to go to court to do that, but I think that that is a form of abdication of the responsibility of the commission in the first instance. It is the obligation of the commission to make that choice. So on the issue of numerosity, I don't think there's a strong basis for the commission to go to court. As I said, I'm not opining about the other issues. That would be a subsequent discussion, but on the numerosity issue, I don't think there's a basis that would suggest that the commission go to court and seek a judgment in advance of its action. So, Mr. Chair, thank you for your indulgence. I think I've kind of summarized and done a thumbnail of the issues in my analysis and my conclusions, and I hope that that is sufficiently clear.
Do the commissioners have questions? Mr. Starling, let me just go down. No. Commissioner Hertzfeld?
I actually do have a few questions, but I'm wondering if it's better to wait until we've heard the presentation from General Cooper
That's
as
fine.
well, perhaps, and then ask questions.
Sure, absolutely. Commissioner Davis? No questions? Commissioner Evans, questions? Okay, all right. With that, if you could kind of let, I think we'll call on General Cooper next. I know you were going to give a 5-minute, but are you sticking with the 5 minutes?
Chairman Delanus, I doubt that I will take 5 minutes.
Okay,
but
all right.
Certainly prepared to speak.
Okay, please.
Okay, great. Can everyone hear me? Well, good. Well, good afternoon. Bob Cooper, Director of Law for the Metropolitan Government of Nashville and Davidson County. Appreciate this opportunity to speak, and I will be brief. The Commission already has our analysis of the signature requirements, as well as other serious issues raised by the For Good Government petition. We gave the Commission a legal memorandum on April 2nd, and yesterday we sent the Commission our formal legal opinion 2021-01, which had been requested by the Mayor and the Finance Director and is a public document. Our formal legal opinion outlines what we believe are the significant defects with this petition, including serious questions about whether the petition satisfies the Charter's signature requirement. I won't belabor those points now. You've had both of those memos. Certainly respect Professor Blumstein, and he's a longtime friend, but I would point to Charter provisions and state law provisions that I think go contrary to his conclusions, particularly Metro Charter Section 9.02, which provides that elections to fill school board vacancies, quote, shall be at the first county-wide general election, close quote, as well as Tennessee Code Section 2-14-101 that says that even special elections shall be held on a vacancy in any office that is, special elections shall be held when a vacancy in any office is required to be filled by election at other times than those fixed for general elections. This was a time fixed for a general election. Therefore, it is by definition, under state law, not a special election. And then, in addition to the issues that Professor Blumstein raised, there are other issues involving the petition that For Good Government, in fact, circulated 2 versions of the petition, and that raises additional issues about how the signatures should be counted. But those are all covered in our memorandum. I'd like to make a broader point, if I could. Last fall, For Good Government submitted a similar petition, as this commission knows. This body sought a declaratory judgment on that petition's legality. The Davidson County Chancery Court issued a 50-page opinion, and that opinion found multiple defects in the petition's wording, form, and constitutionality. Those defects were fatal, and the petition did not go on the ballot. Now, 4GG says that it has learned from that court ruling and fixed those problems, but it has not, for all of the reasons set forth in our legal opinion issued yesterday. Now, For Good Government has already initiated a legal action where the signature requirement and these other serious legal questions can be best and most efficiently determined, and that is in a court of law. This election commission has the authority to seek a declaratory judgment, to ask a court to decide these legal issues. And that is what you did last fall. And it makes sense to do that again now. A special referendum election will cost Davidson County taxpayers almost $1 million. That is a lot of money to spend on a petition with so many defects. The signature requirement, it is a close call. The court rulings do not provide clear guidance on this. But the property tax and sports team provisions in the new petition are not close calls, for example. They are clearly illegal and invalid under the Chancellor's prior ruling. And those aren't the only defects in this new petition. This commission should not spend almost $1 million on charter amendments that will be voided almost immediately when there is an alternative process. If you are not certain about the validity of this petition, then the prudent course is to seek judicial guidance. Now, the issues around this petition need to be resolved quickly. And we saw last year that the judicial process will move quickly. The best route to resolution is for this commission to seek a declaratory judgment action as soon as possible on all of these issues, including the signatures. And that is what we urge you to do. And obviously, we'll be happy to answer any questions. Thank you. Thank you, Mr. Chairman.
Any questions by the commissioners?
I actually have a few, and I'm not exactly sure who to address them to, but I think if it's okay if I go first. You were looking at me, so I was thinking maybe that's what you thought. Okay, great. I actually have a question, I think, for General Cooper, and it's, I haven't asked you this question before, so I don't know if you'll know this off the top of your head, but I'm wondering, there's some different issues that have come up in reviewing the petitions and looking at them. For example, the way that the petition was sent out, it is like a fold-over form with signatures that can be on the front and signatures that can be on the back. And I'm curious if it says anywhere in the law that you know of, or Professor Blumstein or anyone else knows, if it says anywhere in the law, if it is appropriate to take signatures that are on the back page when the back page does not include the language of the referendum on that same page. Do you see what I'm saying? So the language of the referendum is on the front of the page, and then you can flip it on the back side, and there is a place that people can sign. But if those were two separate pages, right, I think our position would be that those signatures are not acceptable because the language of the referendum is not on that second page. And I'm curious if there's anywhere in the law that indicates having it on the back side of the same page is adequate or acceptable.
We have noted that, and frankly have had questions internally about the adequacy of a situation where it may not be possible to see the actual mandatory language if you are a signatory. That is something I think that we will look into, but I do not have any case law to cite you to other than a general concern, and I think a general principle that that someone who is signing a petition should have a reasonable opportunity to understand what the petition is requesting.
And I think this was probably outside of the question that we'd asked Professor Blumstein. I don't think it was, I'm probably putting you on the spot, but do you know anything off the top of your head that indicates one way or the other?
I'll stand up. I was not, as you know, Ms. Hertzfeld, I was asked to look at the number of signature issue, and my understanding was that would be a second-order question if there were issues that had to be raised for the commission's consideration. I'm not, because the mic is not quite right, I didn't hear everything that you said, but I think my understanding is that you were asking if there can be a signature on the back of a page where there's a description on the front of the page. Is that?
That's correct, sir.
Yeah. I can't give you a definitive answer on that. I'm not sure exactly how you would have something that would be a signature and a description all on a page. It would have to be a pretty big pages, pretty small type print. So I have a practical concern about that, but I can't cite you a particular statute or case because that was really not within my sphere.
Okay, and I didn't think we asked you, so I'm sorry to put you on the spot for that. And I guess my question is, and because I think there are two different versions of this petition that have circulated. The first version, I think, had the ability to do the signatures on the back, but the second one really had, circulate this to 10 people, and I think that was on generally the same page. So I think it's possible to have the voluminous language of the various provisions of this petition and, a spot for a signature on that page, as evidenced by the second petition that was circulated here. So that was my first question, and I'll be very transparent with the commission. I did a bit of research myself, and I couldn't find anything about having, front page versus back page. I mean, I looked, I couldn't find it, so I was hoping maybe somebody else had, but I hadn't seen anything, at least in Tennessee law. My second question is, we've received, well, actually, before I get there, does the staff know how many of the signatures that have been presented were actually on the back page of a petition?
We do not have those numbers.
Could we get those numbers?
We could get those numbers. It would just take us a little time. We'd have to go through and count each
By
sheet of
hand.
paper by hand.
Okay, thank you. I've also received some emails from some individuals who have asked to have their names withdrawn from the petition. They've been emails. I haven't gotten anything with an actual signature. I'm sure that the rest of the commissioners have received them as well. And my understanding is that Administrator Roberts has also received some letters from some people trying to withdraw their names from the petition. Do we have a provision for that in our law that permits withdrawal of names from petitions?
Let me say, and I need to couch all of this, Metro Legal is not providing this commission with legal advice with regard to this petition. So I would be hesitant to present something to you that might be construed as our legal advice to you.
I appreciate that, because I think we said that you had a conflict before, and so we were hiring Professor Blumstein for this particular limited issue, and I'm now seeing the issue that so many other things crop up, and it looks like we don't really have advice on that. So I do know that there is a provision to withdraw names from a petition. How that intersects with Metro law seems a bit unclear, but in total, Mr. Roberts, how many requests to withdraw names have we received?
We have approximately a little less than 100. I don't have the exact count. I think I've got 15 emails. I've got about 75 actual documents that were turned in today. So I would say less than 100.
Okay, great. And then I guess my only other question, and perhaps I don't really know who to address it to, but if anyone has an answer, I can't quite figure out if it is required by Tennessee law or by the Metro Charter that a petition have a due date to have it returned to the individual in order to have it submitted to the clerk. I do know that there are various requirements. They have to go on a petition. And the reason that I ask is we have two different petitions here that have been circulated. And other than the form of some of the signatures being on the backside and the fact that they have different due dates for when they want to bring the collection back, I haven't seen any other differences between the two petitions. So I'm wondering if anyone knows if having that due date, give it back to me by March 3rd versus give it back to me by March 25th, is a requirement under any law regarding petitions, whether that be state law or Metro law. Does anyone know the answer to that question that can tell me?
We have addressed this issue in the formal opinion we issued yesterday. The charter requires that a petition prescribe a date for the election that will be no less than 80 days after the petition is filed. And so that is how those two provisions interact. There has to be a date for a referendum election put on the petition, and then the petition has to be filed at least 80 days prior to that election date.
And to just follow up on that question, but it's a very precise question. It doesn't seem to me that there's anything in the law that requires that you notify the potential signatory of that referendum petition that you must return it to me by the 25th, for example. I may have a requirement to turn it into the clerk by the 25th to get to the election date, but in order to have it back to me to collect, to then file, that portion isn't specified in the law. Is that right?
The charter language is specific about the deadline for filing that there has to be a election date prescribed, and then that the petition has to be filed at least 80 days before that election date.
Okay, I think that answers my question. Thank you. And then I just have a couple more questions. I think I'll have some more for Professor Blumstein when we get to another portion of the agenda. But before we get there, we have received numerous opinions. We've now received, I think, 2 different opinions from Metro Legal, one which was made public, and then the other one that we'd received in our attorney-client capacity. We've also received the memorandum from Professor Blumstein, and given that they've both been talked about and it's such a public import case, I would actually request that we make all of the opinions that we've received on this issue thus far, public, so that folks can see that. I don't know if anyone has any objection to that. And
I don't know that we need a motion, but is there any objection to that? Okay. No, with no objection. And it may be that we want to put Mr. Roberts' letter in the record also, since he sent that to Professor Blumstein and he's referred to it in his discussion.
I think that's an excellent suggestion. I don't have any more questions at this time. Thank you.
Mr. Chairman, I'd like to address this to Professor Blumstein.
Yes, Mr. Story?
I hope you can hear me okay.
Yeah, I think I can. I'm sorry, I've got this plexiglass.
Sure. I'll try to talk loud. I know you quoted some case law, and some of the laws you talked about that each case can be reevaluated. Kind of explain.
I didn't hear that last point, Mr. Story.
Reevaluated.
Okay.
Could you explain to me some of those cases that can be reevaluated that pertain to what we are trying to do?
I'm sorry to say this, but could I ask you to say that question again so I can?
Sure. If I don't get put in jail, put my mask down. I'll just pull it down. You mentioned about the cases can be reevaluated, some of the case laws that you quoted. And I was just, can you hear me?
Yes.
Oh, okay. And I was just wondering, can some of those cases that you quoted, they can be reevaluated, which is state law? Can that be reevaluated?
Yeah, I don't remember talking about cases being reevaluated, but cases that the Tennessee Supreme Court have decided can always be reevaluated, just the way every case can be reevaluated. But it must be reevaluated by the Tennessee Supreme Court. It's binding on the lower courts, and it's certainly binding on this commission, unless and until the Supreme Court, if it's a Supreme Court case, has reappraised it or reassessed it. In my memo, I think I made it clear that the Tennessee Supreme Court in 2018, in the Wallace case, the Ludwig Wallace case, reaffirmed this earlier 1983 decision. And so it has not evaluated the portion that relates to general municipal officers. That's still the law. It's binding on Metro. And I think Metro objects to this. That footnote, which was in both Director Cooper's initial submission and in the formal opinion, that footnote is there, which to me suggests that they disagree with the Wise case. And it can be reevaluated, but not by the commission, not even by the trial court or the Court of Appeals. It must be reevaluated by the Tennessee Supreme Court. And since the Tennessee Supreme Court reaffirmed that position in 2018, I don't think it's likely that it's going to change its mind on that question right now. Okay. Is that responsive?
Sure. Thank you.
Question? Thank you.
Does anybody have any further questions for Mr. Cooper? I didn't go around the room as to Mr. Cooper. Mr. Davis, do you have any questions for Mr. Cooper? Mr. Evans? Mr. Cooper, I've got a couple questions, please. I think what you told us in your last opinion letter to us was that the August election, although you're arguing that we ought to use a different election, clearly the August election is a Metro general election so as to be an appropriate election to use for the numerosity requirement. I mean, is that true?
No, we have stated in the opinion that the August election would be considered a municipal general election.
Right. So,
And
sure.
we think that there is also a credible argument to be made that the November election would also be a
Right.
municipal general election. But yes, both would fall in that category.
So August clearly is a Metro general election, but I think you said in your opinion that you thought the November election was defensible. You could defend that, but it's never been squarely addressed by a court. Is that correct?
That's correct. The case law has only dealt with November general elections in which no municipal office appeared on the ballot.
Right.
November 2020 is different in that it did have a municipal office on the ballot.
So that the November election, if it went to court and the court had to decide whether November was the correct one rather than August, choosing the November election would be a case of first impression. In other words, no court in Tennessee, to your knowledge, has ever done that before.
I'm not aware of a court ruling one way or the other on that issue.
All right. And you're not aware that this commission has ever done that before. In other words, use a November presidential election to set the number of signatures for a referendum.
I'm not familiar with that. I'm also not sure that the commission has ever been presented with the issue.
Okay. But we have used August many, 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 many times, correct?
I don't know whether it's many, many times, but you
Or
have
many,
used it
many,
in the
many
past.
times, but we've done it, right? Okay. To your knowledge, have we ever used any election to set the number for a referendum other than an August election?
I would have to look at that. Our focus has been on the elections that were presented by the three cases that are, that have set the precedent on this.
Okay,
So
so-
not look to see what the practice has been in other situations.
Okay. But you do know that in 2006, the voters approved a very similar measure to this one by a referendum petition, correct?
I would disagree that that was a very similar resolution, but they did, it was approved in there was a provision, charter amendment approved in 2006.
And it dealt with a limitation on the taxing authority?
It did include a limitation on taxing authority. It did not attempt to set property tax rates by referendum, and so it's a significantly different provision.
But it did require a referendum to raise those tax rates above a certain amount, correct?
It provides, as I recall, a overall cap over which
Right.
referendum would be required.
Okay. And that language from that referendum is today in section 6.07 of the charter.
It is.
And the Metro government has never gone to court to challenge that.
The Metro government has never tried to raise rates above that limit, and therefore there's a significant question as to whether they would have standing to raise that
And-
question until there was a factual basis.
And the election used to determine the number of signatures required to put that referendum on the ballot was an August election, was it not?
I have not researched that.
Okay, all right. Now, it says in section 6.07 of the charter that, and I quote, "The willingness and ability of the citizens to bear the burden of tax increases should always be considered." Do you understand that's in the charter?
I assume you're reading that correctly.
Okay. Now, going to the dates, I think you've raised an issue on the dates of when these versions of the referendum petition were supposed to be turned in, or at least were requested to be turned in by the people proposing the referendum. We've basically got March 5th and March 23rd as the two dates that they were requesting that the petitions be handed in.
I believe that's correct.
Okay. Now, both of those are legal dates, correct? I mean, there's nothing illegal about the March 5th date or about the March 23rd date.
The dates that are essential are the other dates on those petitions, which state that the dates when the petitions need to be filed. And what creates the confusion here is that contrary to the charter, there were two referendum election dates placed on both versions of the petition.
Okay. Okay. So it's really not the March 5th and the March 23rd dates that cause you difficulty, correct?
What is contrary to the charter is stating two separate referendum election dates on the same petition, since the charter requires a date for the referendum election to appear on the petition.
And that's not a numerosity of signature issue.
But it has an
That's
impact on the
something else.
numerosity of signature issue, because essentially what has happened here is that one version of the petition relies on the first stated referendum date. The second version of the petition relies on the second stated referendum date. And so people who signed different petitions were signing, in fact, different petitions. One for a petition calling for an election on the first date, the other for a petition calling for an election on the second date, and those cannot be aggregated for purposes of meeting the signature requirement. That is what we have explained in our public legal opinion.
Okay, and in the opinion you sent us, I think the first opinion you sent us a couple weeks ago, maybe 10 days ago, you based your conclusion on your argument that Tennessee requires strict compliance with the election laws.
That's correct. Tennessee is not alone in that.
Okay, well, now, Tennessee is a substantial compliance state for purposes of election laws unless a statute specifically says otherwise, isn't it?
Tennessee is a substantial compliance state with regard to some provisions, but with regard to these sorts of provisions, Tennessee has made clear that there is strict compliance. You cannot get your petition on the ballot if you almost have enough signatures. You cannot get your become a candidate for election if you turn in your petition 10 minutes late. And likewise, you cannot have an effective petition if you don't follow the requirements set forth in the Metro Charter, which are the equivalent of what the state provisions, comparable state provisions are, that are strictly enforced in Littlefield v. Hamilton County.
But you do agree, if I understand it, that Tennessee is a substantial compliance state for election law issues unless a statute specifically provides otherwise.
I believe I'll stand with my statement.
Well, are you familiar with the case of Lanier versus Revelle from the Tennessee Supreme Court in 1980, in which that's exactly what that court said?
I think the more relevant case is Littlefield versus Hamilton County, Tennessee Court of Appeals of 2012. That is more applicable to this situation.
And you know that that case is an unpublished decision, and it specifically relies on a statute that specifically does not apply to Davidson County. You know that, don't you?
It applies to requirements on the state level that are functionally equivalent to the requirements in the Metro Charter.
So you're saying that that case, because it refers to a statute, you are applying that to the charter. Now,
I'm applying it to mandatory requirements in the charter that are comparable to the mandatory requirements in state law on which Littlefield is based. But I think the point here is that there are significant legal issues being presented by multiple parts of this petition. And we can be here all day trading these questions. The point is, what is the most efficient way for this commission to get those questions resolved? And we would suggest that on important questions like these, that to get it right, the best thing is to go to the court and ask them for guidance.
well, okay, I understand you're arguing for declaratory judgment, but let me stick on this question about substantial compliance. Are you aware that the Tennessee Supreme Court is a stronger precedent than an unpublished decision from the Court of Appeals? So Lanier versus Revelle can't be reversed by an unpublished appellate court case from a lower appellate court. Isn't that true?
Mr. Delanis, why don't we get the conclusion here, whether you and I debating legal principles here. There are, I think, strong precedent, as we've laid out, for our legal position. I think you're comparing apples and oranges with the two, with the analogy you're attempting to make, but I'm not sure that's really necessary for us to be, and we're not going to get resolved this afternoon.
Okay. Are you aware that in another decision, this one from the Court of Appeals in 2001, that in the setting of a referendum, that the Court of Appeals said that, again, reaffirming the Lanier case, that substantial compliance was all that was required, and it basically said no harm, no foul. That they said no harm, no prejudice, therefore there's substantial compliance with the law, and that in your latest opinion to us on this issue of how substantial the compliance needs to be, you cited a Nevada case, and you didn't cite us to any Tennessee cases. So we got these Tennessee cases on one side, and we've got a case from Nevada on the other side. But, I mean, Nevada doesn't tell us much about Tennessee law, does it?
Mr. Delanis, I have not recently reviewed the cases you are talking about. It is clear that under Tennessee law, some provisions only require substantial compliance. Others require strict compliance. This is one of those. We are quite comfortable in saying that strict compliance is required. And we think that a court, were it to be presented with this issue, would agree with us.
On the issue of the character of the November election and whether or not the school board election was a special election, you're, I think, relying on Tennessee Code 2-14-101, where it says, where it talks about special elections and when they're required.
Yeah, among other precedent, yes.
Okay. Have you looked at the notes? I think there's the official notes to that statute that you cited to us, where it says the general rule is that only a substantial compliance rather than strict literal compliance with the election laws is required, so that absent proof of fraud, the court would not hold illegal either the ballots of persons who merely voted in the wrong precinct or the ballots of women who had married since their prior registration, et cetera, and they go on to explain this substantial compliance rule. And then the next thing in the law book is TCA 214-102 that says the time of holding a special election. And are you aware that the special election of the school board district that was attached to the general November election, that was used to place the time of holding that special election? You see in that statute where it says the time of holding a special election, and are you aware that this commission relied upon the statute that says the time of holding a special election to put that school board race and hold it at the same time as the November election?
Chairman Delanis, can I interrupt for just 1 second? Which, where are you, so I can follow along? Which
Yes,
page?
214-102.
Which page?
It's on page 292 in, I think, the last book. This is the, do you have the
yellow book?
219?
Yellow book?
Yes, yellow book.
Okay, and where are you? Compliance with election law, that first note?
Yes. Well, I was actually read beyond that to 214-102, time of holding special elections.
I'm having,
Here.
I don't mean to interrupt you here.
Sure, no, that's
I'm
fine.
really
Here.
I'm having a hard time
Here's where
following
I
you.
am. Here.
You're here.
I was there, but then
Married women, blah, blah, blah.
Yeah, then I was asking questions about that.
Timing of holding
Yeah,
special
yeah.
elections. Okay, got it.
So-
Thank you.
So the timing of holding that school board race was set by our using and applying the statute that says the time of holding special elections, correct?
Mr. Delanis, there were multiple questions I think you asked me in that last statement.
Well,
I would say that
I talked with Commissioner Hertzfeld, and then I came back and asked you a question that was along the lines of the special election for school board was one that we set in November using this statute, 214-102, that is titled the time of holding special election. Are you aware that that's how we did that? How the election for the school board got to be set in November?
I'm aware of this statute, yes.
Okay.
Chairman Delanis, while you're taking a pause to look at your next questions.
I'm ready to go, though.
Oh, you are? Okay,
Yeah. I mean, one more question. I think maybe one or two, hopefully. But you mentioned $1 million.
Almost $1 million. I think is
Yeah,
what I
well,
said.
I think our AOE has said 800,000, but, let's not quibble. There's going to be attorney's fees, et cetera. And this is going to court anyway. I mean, it's not, this is going to court. This is not a question that it's not going to court, because if we decide to put this on the ballot, your office is going to sue us. So saying it's going to cost $1 million is not, I mean, that's not really true. It's, we're going to get sued, and the court is going to decide. The only issue is what we do in order to put the issue before the court, isn't it?
There's a significant difference in cost between a special election and legal fees that you might incur with regard to seeking a declaratory judgment.
So you're saying that if we file a declaratory judgment, it's going to be cheaper than if we make a decision that you sue us on, or your office sues us
No, I'm
about?
simply saying that scheduling a special election will be significantly more expensive than seeking a declaratory judgment. That is, I think, your experience from last fall.
Our attorney's fees were what, over 200 and some thousand dollars, weren't they? Yeah. Okay. So I can't agree with what you just said, but those are all the questions I have at this time.
Can I just ask one quick follow-up? I just want to be clear, we don't have anyone advising us on the actual substance of the petition itself at this point, right? We do not have a lawyer on that issue. We've received the opinion of Metro Legal, and Professor Blumstein was hired only for the numerosity issue, but for all the questions as to whether the petition is appropriate and if it follows a court order and if it is in line with state and metro law, we haven't received independent advice on that
Not yet. That's number 4 on the agenda.
Okay.
And hopefully we can move that down the road very quickly.
Okay, great. So I'm going to just reserve my questions on the substance of the petition and whether it's appropriate to be before the voters until
Right.
which
Yeah.
time we've received
Yes.
advice.
I agree. It's on the agenda for today, but I anticipated that we would move it to a more appropriate meeting once we get that legal advice.
Okay, then I will reserve the remainder of my questions. I don't know if anyone else has any. I wasn't really prepared to ask those questions today because I knew we hadn't gotten there. So I think the chairman and I are probably on the same page.
I agree, yes.
Lovely, thank you.
Okay. Are there any other questions at this time for Mr. Cooper? With that, I believe, Mr. Roberts, you're next up.
And I'll make my comments sort of brief. I would first thank Professor Blumstein, who I have not seen in 25 years. It's an honor to be in your presence, sir. And I appreciate your service to both the Vanderbilt Law School and this election commission. And I appreciate you accepting and reading an email that I was sent to you. So thank you very much for doing that. I would like to just quickly address really the elephant in the room here, which is quite simply that Metro Legal or the Metro Department of Law does not represent you. They do not represent the Election Commission, and I've been told that recently, and I believe Mr. Cooper has said that publicly at the April 6th meeting, I believe, in relation to the lawsuit that I did file on April 2nd. They do not represent you, and they never really have. They represent the metropolitan government, and we shouldn't kid ourselves that the metropolitan government has no interest in the people voting on this referendum or the 6 amendments in this referendum. They simply do not. I would ask this ask this body to think about what the Fraternal Order for Police versus the Election Commission case. It's only 2 years ago, the issue of preceding general elections was addressed by the court. And in that case, and I'm sure you've discussed it or will discuss it, I would like to point out one thing, is that they looked at the mayoral election. When we replaced our mayor in 2018, the Court of Appeals said a countywide election where every citizen got to vote was not a preceding general election because it was a special election. And the Metropolitan Department of Law argument seems to be or has been that a school board election that represents 1/9 of our county's population, it represents 4 councilmatic districts, is somehow the same thing or greater than a countywide mayoral election. And the best I think they can really argue on that is that there's no prior legal opinions on that issue. And I would submit this because no one has ever had the audacity to make that argument. There's no way that this body should consider the November election a preceding general election when clearly state and federal elections don't count. And if this body were to do that, then I would ask it to, if it were to decide that a election representing 1/9 of the county is the election, then look at the number of people who voted in that election. Going back to the Article 1901.01 of the Metropolitan Charter, it says the number of voters who voted in the preceding general election. It had to have been in that election. And in November of 2020, about 33,000 people voted in that school board election. And if that's if that's going to be the election, if that's the one you're going to count, then you shouldn't count the state election in the November, and you shouldn't count the federal election in November. You should count that one school board election. In that case, only about 3,300 signatures would be required. The same should apply in the August election. There were 4 elections for metro offices, 3 of which were special elections. Again, they don't count. The only election that should count is accessor of property. And we know that that's a valid election because attached to that complaint, which hopefully you have seen, is the Metro Legal's own appellate brief, where they argued strenuously that the assessor of property election in 2016 was the only preceding election, and so therefore that reasoning should count in 2020 because the assessor of property, of course, is every 4 years. Any suggestion otherwise, I submit, is untenable. There have been, and I won't get into the whole argument. I think Professor Blumstein did a excellent job, and Mr. Delanus, Chairman Delanus, brought out some of the major points. I would like to bring one last thing to your attention. I'm not here to sort of convince you. I think the law is clear, but I would like to bring to your attention that it's my understanding on Tuesday, April 13th, the list of voters was released. Within 24 hours, a fictitious group called Citizens for Responsible Government, a group that does not exist, cannot be identified, was a defunct nonprofit that the Tennessee Secretary of State dissolved over a decade ago, sent out thousands of letters. My phone an email has been blowing up the last 2 days, intimidating people, misleading people, trying to get them to retract their signatures. There has been a organized robo-calling, robo-texting. People have been going to people's houses. What we see is an incredible attempt at voter suppression. And I'm asking you not to be a part of that. Those folks that are doing this, that are harassing people, going to people's doorsteps, elderly people's doorsteps, and scaring them, using a fictitious entity, lying about what this petition does, what we have attempted to do, that's what we're up against here. And I'm asking you not to be a part of this. There is going to be action taken about this. And the reason it hasn't been so far is that these folks are hiding themselves. They are directing people to a website whose information is hidden. They are directing people to an organization that doesn't exist. All we know is one phone number, and we're tracking that down.
Mr. Roberts, you went over your limit about 30 seconds ago. Could you wrap up?
So that's all I just want to give this body notice that that's coming. I strongly suspect that they will approach this body and try to say they've rescinded these signatures. The fight's about to begin. Let's deal with today, and I look forward to your vote. Thank you.
Excuse me, Mr. Chairman. I
Yes, sir.
represent an organization, and I would like an opportunity for no more than 3 minutes. And if that will help persuade you, as the winning lawyer in Wallace and FOP, happy to tell you that the preceding general election for this purpose is the August 2020 general election.
What organization is that?
I represent the Nashville Business Coalition.
Okay, all right. Commissioners, what's your pleasure?
I would like to hear from Mr. Holland.
Okay, all right. Is that, okay, all right. Okay.
Could you help
all
me,
right.
Mr. Kelly? Well, we had new members, Mr. Chairman. I want to let them know, and I'll let Professor Blumstein know, too. But good afternoon, Mr. Chairman and Commissioners. For some of us, this feels like deja vu all over again. Rest in peace, Yogi Berra. I'm Jamie Howell on behalf of the National Business Coalition. And as we mentioned, I litigated those cases you've been reading about and been lectured to, beginning to end. They all started right here. And as the chairman said, there's no question it's going to litigation. As a preliminary matter, I need to object to the commission's consideration of multiple versions. Language is not the same and cannot be considered together. Indeed, they're separate. Also must object to the signature verification process. You'll note in that handout, you've got 2 signatures. Mr. and Miss Hardwick, let's call them. Top line, street address, street, city, state, zip, check mark. Verified signature. Next line, quote, 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 quote. Check mark, signature verified. When I was down at the Election Commission on Tuesday, I asked for a copy of the rules governing the verification process. It was printed out for me. I'm sure y'all know about it. If not, I've got one to leave. But on the last page, it says, dittos used to designate address don't count it. Not my rules, rules of the commission. I make that part of the record as well. Here, clearly and in violation of your own rules, the petition signer's name was verified in spite of the rule disallowing it. The process followed by this commission is seriously flawed. Existing lawyers, when they agree with you, some you don't, then you fire them, call them adversarial. I'm not sure of the propriety, but the chairman sent a letter to the Part 3 chancellor, which is expressly prohibited under the conduct governing attorneys, especially one in a representative capacity. Review the opinion of the law director. Take it seriously. This latest effort is as irredeemably flawed as the prior effort. Third, we're way past partisan politics. Instead, this is about substantive matters of law. If you put the new petition into the law order, 50-page order, there's only one conclusion. The petitions can't go on the ballot as a matter of law. At worst, seek a declaratory judgment. At best, disallow it. At minimum, act as though the money's coming out of your pocket to pay for it. Thank you.
Thank you, Mr. Holland. Do any of the commissioners have questions for Mr. Holland?
I just have one quick one about the petition that was handed to us. The petition that was handed to us, it's supposed to be folded like I was talking about before. Is that right? Is that your understanding of how it was sent? So it'd be folded like this on the front, the language of the petition on the inside, and then there's an additional signature page on the back.
That's correct. And most of them, 14,000 pieces of paper, it's hard to put your hands on all those in any particular reasonable amount of time. And I was only there for a limited time. But a great number, certainly greater than 256, have the signatures on the back. And if this one got the check mark verified in expressly opposite of your rules, it is one. We're talking about 256, 255, and he doesn't get there. So I think your verification process needs to be reviewed.
Thank you, Mr. Holland.
I do have a question, Mr. Holland.
And who do I need to give this to so this could be in the record?
Give it, okay. Yes, you can
I'm
give
the
it to Tricia.
secretary,
You can
so-
give it to Commissioner
I'll take
Hertzfeld.
it. Thank you so much.
Mr. Holland,
Yes, sir.
you came to the commission offices and you were given as much time as you needed to inspect the petitions and the signatures. Okay. Mr. Holland, you came to the commission offices and you were given as much time as you wanted to inspect these petitions and the signatures, correct?
What I was doing was trying to, we got 14,000 signatures or 14,000 pieces of paper. It's hard to, how you gonna manage it? So we had a copier, because we had asked for, on April 6th by email, I had made a request to get copies of them made. That did not appear to be forthcoming anytime soon. So I went down there with some other people to help, with a copier, putting them two up on a screen and scanning them in.
Right.
And I don't know how many we got. We certainly didn't touch every one, but
Right.
there's only so much you can do in an 8-hour day.
Okay, but just so I'm clear, nobody made you leave. You had your own copier and you were able to inspect and copy as you wished, correct? Okay, all right. And we've got, this is what you've got, okay.
Can I ask a question of the administrator? Just while we're on the verification of signatures thing. I think it's probably interesting to know for the public how it is that the signature verification happens, that we have staff that go in and then they verify the address. I just want to make sure I've got this correct, but they verify that the address that the person that signed the petition has put down, that is the correct address that we have for them. They verify that the signature matches the signature that we have on file for their voter registration, because of course someone who signs the petition, for it to be valid, they must be a currently registered Davidson County voter. Is that correct?
That's correct.
And I think that, you know, some of us have an idea of how this signature match process would happen. Perhaps we have, if we're old enough, we think back to how things were in Florida with the Bush v. Gore, you know, variety of hanging chads, and everyone can look at a different, you know, a different ballot. But you would think that someone should be able to sit down and watch people verify that there should be maybe a bunch of people in the election commission room, and they're looking at it going, okay, this signature matches here. I'm going to mark yes, and we're going to move on. But we're not actually able to do that pursuant to state law. Is that right?
That's correct, because when we're verifying the signature, we're also bringing up the entire record for the individual, which displays their Social Security number.
And so because we have to keep the privacy of an individual's Social Security number private and secure, because that's required pursuant to state law when you register to vote, it makes it impossible for members of the public to watch that signature verification process. Is that right?
That's correct.
Okay, I don't have any other questions. Thank you.
This is Jim Delanis. Mr. Jeff Roberts, can you just briefly describe to us, as you have before, the number of times these signatures are checked by your staff?
So initially, when the petition came to us, our first pass at verifying the signatures, if we got a quick match on the signature, those were set aside. If we did not get a match, that signature was highlighted, and we would then pass that on to a second different individual that would look up this the voter to see if we had multiple signatures on file. A lot of times people will sign their driver's license on a keypad a little bit different than they sign their checkbook, per se. So we would go back and look at all of the signatures we have to see if we had one that matched. If we didn't have one that time, we also set that aside, and a third person would look at that. The third person would actually go to look at the hard copy of the record that we keep on file in our office. So we went through a process of looking at the signatures, some of them 3 times, to make sure we gave the voter the benefit of the doubt that we did everything we could based on the information we had to match their signature.
Is there anything further? Okay. Commissioner Davis, yes, sir.
This is Commissioner Davis. May I have Mr. Holland come back up for a moment?
Absolutely.
Yes, sir.
All right, a couple questions. One for I heard it, but I want to make sure I heard it. So you litigated the Wallace and the FOP case, correct?
That's correct.
And what were the outcomes of that litigation?
So winners, both of them, but the chairman doesn't like this, but the 2018 case, I represented the plaintiff, Ludy Wallace. The election commission got it wrong. I begged them at that meeting and a subsequent meeting to put it on with the transit referendum. That way it wouldn't cost anything. Ultimately, we go to the Supreme Court on what's called a reach-down motion, and the Supreme Court ruled in our favor.
And the other one?
That was about the community oversight now's petition drive to get a, to get a community oversight board established. And I represented community oversight, Metropolitan Department of Law, represented Metropolitan Government, and the Election Commission got it right, and I advocated in support of the Election Commission's decision then, and against it in the Wallace case. Frankly, I'm here to help you get it right.
That's not my question, but thank you. Second question I have is that the other day, what day did you go down to look at the signatures?
It was Tuesday or Wednesday. I think it was Wednesday, but my ability to keep up with days these days is getting out of control.
Well, that's interesting. How long were you
I
there?
think it's Wednesday. I walked in the door at 10:30, left approximately 3 or 3:30.
So you spent 5 hours roughly.
That's correct. Was I looking over every petition? No. What I was doing was trying to separate out as many petitions, because I had to prioritize. I realized very quickly, due to the slowness of the process, I wasn't going to get close to all of them. So I was trying to get the ones I could. And so what I prioritized was the ones that had signatures on the back with no ballot language. I called that a naked, in my mind, I called that a naked signature.
So you didn't inspect all of them then, correct?
That is correct.
No further questions.
Thank you.
Any other questions for anybody? Are we ready to discuss voting on the numerosity issue?
I think we had decided we were going to hear from the public first.
I'm sorry. Thank you. Yes. Anyone from the public wish to speak on the numerosity issue? Would that be divided up or just generally?
I think if people are here and they want
I want to go home.
speak
Okay,
about whatever,
sure.
I would say let them
Okay.
speak about whatever if they've come.
Yes.
I'm going to be called on. I just need to use the restroom.
Okay. No, I think you're fine.
I'd be happy for a comfort break.
Okay, fantastic. Yes, let's all, we're all going to take a short break, and then when we come back, we'll hear from the public. Everyone who's signed up will have 1 minute to speak, and you may, if you decide on this break you want to speak, please sign up. 5 minutes. Yes, ma'am. Okay. Who's got the list? Here you go. There you go.
Back at 2:45.
Chairman Delantis,
Yes, sir.
before we start on the public portion of this, I would like to follow up on one question you asked before. I have some additional information that I'd like to put
All
in.
right. Yes, sir.
If that's okay.
Yes.
You had asked about whether the school board election on the November 2020 ballot was set pursuant to Tennessee Code annotated 2-14-102, which is the general provision on special elections. In fact, it was not. That was set pursuant to a specific statute dealing with vacancies on school boards. That's Tennessee Code annotated 49-2-201, part of the General Code on Education, which provides that vacancies occurring on a school board shall be filled by the local legislative body, and any person so appointed shall serve until a successor is elected and qualifies according to law. And then the most pertinent language, the successor shall be elected at the next general election for which candidates have sufficient time to qualify under the law. And then that time to qualify under the law is governed under Tennessee Code 5-1-104. So that November 2020 election was not set pursuant to 214-102, but rather pursuant to 49-2-201.
Wait a minute, let me take some notes here.
Sure.
So first, you took us to 49-2-201, and what part of 201?
That is in A1.
A1, okay.
Mr. Chairman, may I just point, that is stated in 2L of my memorandum.
Okay.
Reference to that provision.
Okay.
Is in section 2L of my memorandum,
Okay.
which references 49-2-201.
All right, thank you. And then, Mr. Cooper, so then you go, where do you take us next?
That then cross-references over to 5-1-104, which talks about the time for filing nominating petitions.
And are you saying then that the provisions where you can combine a special election with a general election that appear in 214-102 had nothing to do with setting the school board election in November?
The specific statute governing school board elections would apply in that particular situation, and that's 49-2-201A1.
Well, I'm looking at A1. It doesn't seem to have a provision that I can see that talks about moving that within the 30 days that we're, I believe, authorized to move a special election pursuant to 214-102, which is what I think we did. No?
No.
I'm wrong about that? Okay.
I think if I understand correctly, looking at Professor Blumstein's memo in paragraph L, as he's referred us,
Okay.
he actually talks about both.
Okay.
And I think they're actually somewhat two separate points. I think it's a technical clarification that General Cooper is making, that it was not, when we set it, because it was a school board election, it wasn't set pursuant to the other provision of the code. It was set very specifically under 49-2-201, which talks about unexpired terms of school board members.
Right. But if I may, Mr. Chair, Ms. Hertzfeld is right. I addressed this in 2L and then discuss it in the next paragraphs following and reach the conclusion that it still is a special election at all, that 49-2-201, and I don't have it in front of me, does is sets the time. It doesn't really change the character of the election.
All right. Okay. Okay, thank you.
Thank you, Mr. Chairman.
If there's nothing further on that point, we are at the part of our proceedings where we take public comment, and I will ask AOE Roberts to call the roll of the people who have signed up. And please confine your comments to a minute unless the commission decides otherwise. So right now, everyone has a minute.
Ms. Cadane?
My name is Rafaela Cohane, and I live at 117 30th Avenue North, 37203. I'm going to make this brief. I'm not an attorney, and I'm grateful for that. I heard Mayor Cooper's announcement about the property rate being reduced. That's not really fair what he did, because of the reassessment, our taxes are still going to be the same. It's just that he has to reduce the rate because they can't have a windfall according to the charter. And the second thing is, the tax rate is only half of the discussion and half of the equation, by virtue of the fact that even if you compare Nashville's property rate, property values with our peer cities in Tennessee, our property is valued much higher than Memphis, Knoxville, or Chattanooga. So we are paying higher taxes, and our metro government has lost its place. The people employ them. They do not rule the people. Thank you.
Thank you.
Mr. Garrett, please.
Thank you very much. Commissioners, it's a pleasure to be here, and thank you for inviting me to speak. I came prepared to talk about the group called withdrawmyname.com as best I could find out about them. My phone started blowing up on Thursday, and I've got a lot of comments. But I wish to change my comments specifically to address, Commissioner Hertzfeld, your question you asked earlier. In 2015, I was a candidate for council. If I recall correctly, my petition there, I think it was either one-sided or two-sided or multiple page. But on the front side, there was a big paragraph at the top that identified me and what I was doing and so forth. And there were places below that for some signatures. I required 25 signatures. There was not enough on that front page for 25 signatures. So I think it was a two-sided form. You flipped it over, and on the back, we did that. Now, on the back was not that full description of everything that I was running for. I think it might have had something at the top, it might have had something at the bottom, but there were provisions on the back for signatures, and I got a second page and a third page where I could get more than 50 or 70 or something like that. So the question about the petition Mr. Roberts submitted being two-sided.
Mr. Garrett, your time is up.
This commission allows
Can you sum up?
candidates a two-sided form. So I'm just pointing out your efforts. Thank you.
I appreciate that, Mr. Garrett. Thank you.
Thank you, Mr. Garrett.
You're welcome.
Mr. Went.
Commissioners, thank you very much for your service to Nashville and Davidson County. It's a difficult time to be guardians of the sacred vote. Thank you so much. I'm not a lawyer either. I'm not an election authority, but I have tried to vote in every election since 1984, since we moved to Nashville, and I don't think we've missed but one or two. I think the issue here is very important. This tax increase has adversely affected our family, as probably many other families. It's an issue of, in my mind, transparency, integrity, and giving people the right to vote and the right to be heard. And I would strongly urge the commission to allow this referendum to be on the ballot so that people can be heard. Thank you.
Thank you.
Ms. Williams.
Hi, can you all hear me?
Yes.
No. Yes? No? Maybe so? So before my time starts, I would like to request some additional time. I was telling Chair Delanis that I had watched the September 25th meeting, and you all gave an average of 4 minutes. And I think you care about public input. I know you've been here a long time, but we've also been here a long time. So if I could get 4 minutes, I would really appreciate it.
Okay, that's fine.
Thank you so much. Okay. My name is Nicole Williams. I live at 4425 West Lawn Drive, and I've been a Nashville resident for almost all of my life. I'm also a property owner, so I was affected by the tax increase last year. And I felt compelled to be here today to voice my opposition to Mr. Roberts' proposed referendum. I'm not a lawyer either, so I can't speak with confidence to the legality of the petition, though I do have serious doubts in that respect. But as a Nashville resident, I can speak to my concerns about how these incessant assaults on our government interfere with its ability to address the real needs of our community. For a group that is so ostensibly so concerned with not wasting taxpayer dollars, For Good Government seems intent on wasting as many of those dollars as they can. They know, and I would argue they hope, that these petitions will be challenged in court. They've used the fact that Metro government and this body chose last year to protect the sanctity of our elections to drum up support for this latest effort. Those challenges cost money. Furthermore, one of the provisions of the referendum would drastically lower the threshold for recalling elected officials, essentially throwing our government into a tailspin with endless recall elections. Those elections cost money. We elect our officials to represent us, and we need to let them do their jobs. And if you're not happy with your representation, do the work to get someone else elected. If enough people agree with you, you'll win. But they know they can't win, so they're trying to game the system to give a small but vocal minority the power to hold our government hostage. Coming back to the matter at hand, I think the case last year shows that this body's role is not purely ministerial. You have a duty to consider whether the requirements for having a referendum placed on the ballot have been met. It's not clear to me that those requirements have been met here. I know that some of you will be sympathetic to Mr. Roberts' cause, but if this body makes exceptions to the rules just because it agrees with the content of the proposed referendum, that calls into question your impartiality. Mr. Roberts argues that you should let the voters decide and worry about the legality of the various proposals after the fact. So what's next? A referendum that says people named Nicole can't vote is fine as long as I get enough signatures and place it among other completely unconnected proposals that may or may not be legal? It's tempting to say we should just let the people vote, but that's like saying we should just let the legislature pass blatantly unconstitutional laws. It wastes the voters' time, it wastes the taxpayers' dollars, and it forces the council and the mayor's office to split their focus in a time when we desperately need them to be focused on addressing the overlapping crises we are currently facing. Over the past year, Nashville has endured multiple natural disasters that have devastated whole swaths of our county. We've faced an ongoing public health crisis. We've endured a bombing in the heart of our historic downtown. Now is not the time to be trying to recall Bob Mendez and claw back resources from our government. I would urge you to follow the letter of the law and reject this latest assault on our government's ability to function. Thank you for your time and for your patience.
Thank you.
That's all, Mr. Chairman.
Okay. All right. Are we now ready to discuss the numerosity issue, commissioners?
Yes, I think so.
All right.
My understanding is that if it is the August election that we're going according to, the requirement would be 12,142 verified signatures. Is that correct?
I think that's right. Yes.
That's correct.
And if it were the November election, that number would be 31,212 signatures. Is that correct?
That's correct.
Okay, and we have verified 12,398 signatures according to the staff of the Election Commission. Is that right?
That's correct.
Okay, thank you.
Anything further, Commissioner, from you on?
No, I don't think so.
Okay, all right. Commissioner Starling?
Not at this moment.
Okay. Yes, sir. Commissioner Davis.
AOC. So you verified 12,398, correct?
Yes, sir.
And you feel very strongly that those are all up and down, straight up, good verified names and addresses and all those things, correct?
The signatures matched the signature we had on file. Per Mr. Holland's document that he dropped off, a copy, It appears that at least one used quotation marks to define the address. Our process to look up the voter, we type in the last name, and then we type in the digits of the address to look the person up. So even with the quotation marks, we did bring up Mary L. Hardwick, and we're able to verify her signature based on that information.
So, follow-up question. Do you feel relatively secure in the process?
You know, per Mr. Holland's comments, he said that he received documentation from our office that said quotation marks were not acceptable on the address. So absent going back and seeing if we have more than this one, how many we do have, I can't say, you know, that the entire process of 12,398 is verified at this point.
Okay. That's all for at the moment. I'll probably have a follow-up.
So I have a question along those lines. So for all the signatures where there are quotation marks or dittos or whatever, then maybe we should go back and verify that they have a valid address. Or have you already done that extent?
As part of the process to call up that voter, their record, we actually type in the last name and we type in the digits of the address to bring up that person. So we are looking up that person. It's whether or not the quotation marks are acceptable. And I would have to see the documentation that Mr. Holland had that outlined that those are not acceptable at this time. I've not seen that personally.
But quotation marks or not, you're still verifying everyone's address and along with their signature.
That's correct.
Either way.
Because we would actually mark the address. If it's not the address that we have on here, identified by the quotation marks, we would mark that as a second check is required to see if that person lives inside or outside the precinct that we have them registered in. If they're inside the precinct, their signature would count. If they're outside the precinct, it would not count.
Yes, Commissioner Hertzfeld.
So I'm looking at the document that Mr. Holland provided, verifying petition signatures, June 2014. We've got one copy of it here that Mr. Holland made a part of the record, which is interesting that we have a record. And is this the form that our staff is trained on to verify petition signatures? Do you know?
I would have to go back and ask the individuals that were actually kind of heading up the verification process if each person actually saw that document. We focused more on the actual instruction provided by the state as far as the signature itself than anything. That was our primary focus.
Which I think brings me to my next question. Are you aware if this ditto, I'm going to call it the ditto address issue, if that's a matter of law or if that's just been our practice? Do you know?
I do not know. I would have to follow up with the state on that information.
And if I could just ask another question, I think Mr. Jim Roberts had mentioned that he has already sued this commission about the number of signatures in the verification process, and that case is currently pending in Chancery Court. Is that right?
Yes.
Okay, and so regardless of how we vote today, that signature issue is already in front of a court.
Well, Mr. Roberts is not here, Mr. Jim Roberts is not here, I'm not sure this particular issue is before the court. The general numerosity issue is before the court. I do know that. And the current status is that there's a motion pending by Mr. Roberts to postpone a hearing on Wednesday on this issue and a briefing schedule that would require us to file a brief by Monday, 2 days hence, to put that off a week.
Okay.
And so he's not here to address these issues with, unfortunately.
Okay.
Mr. Chairman, if I could, Chancellor Lau granted that motion.
She did.
And extended the hearing until May the 5th.
Oh,
Okay.
okay.
So then to follow up, I hate to put you all on the spot, but at this point, is the Election Commission saying that we have 12,398 signatures verified for this petition? Or are we saying, we probably need to go back and double check based on this information that was given to us by Mr. Holland?
Based on the information provided by Mr. Holland, I think it'd be wise for us just to double check to make sure that the 12,398 stand as a total.
Okay.
Okay. And
How much time do you need to do that?
I would hope we could finish that in 2 days if we put the entire staff on that project.
Okay. All right.
And yeah, Mr. Chairman, I'm not sure that I don't think we can vote at this point if we don't have a verified number of
No, I understand.
signatures.
No, I don't think, well, I don't know if we need to take a vote on that, but if you want to make a motion,
Yes,
that'll
I
be
will.
fine.
I'll make a motion to take agenda item 3, discussion and possible vote on number of signatures required on petition, and to move that to our next scheduled election commission meeting, which I'm sure we'll schedule later this meeting.
Mr. Chairman, can I respond to
Yes,
that?
yes, Professor
I think
Blumstein.
There are 2 separate questions. One is how many signatures are needed, and the second is how many signatures were obtained. Those are distinct questions.
Right.
Because I've been asked to deal with the question of which election. I think Commissioner Hertzfeld's motion goes to the how many signatures were obtained.
Right.
But I think the commission can certainly vote at this point about which the relevant election is for purposes of the signature requirement.
And I think typically we do it all as one vote. We say that there's enough or there's not. I don't know that we've ever broken that up into 2 separate questions before, and just being mindful of the fact that we have so many other, I'm sure, petition and signature issues ahead of us for the commission in the future. I probably would want to stay with the precedent we've had, which is making a decision in general, as opposed to breaking down each element of the decision. Because I think if we do that now, we're going to have to do that for every vote we take in the future on certification. So I'm happy to have, I think we've already heard everything we need to hear, but I would move that we move the entire issue to the next calendar.
If the commission should determine that the larger number of votes are required, then there would be no need to go through this process of refining who's counted or not. So I think that those are, in other words, you'd have the staff doing something that would be totally unnecessary if the November election is deemed to be the election. And then that would kind of move forward. And so I would urge, in my role as counsel on this issue, that the commission determine which the right election is now, and then if there's a question of how many votes are properly on the signatures, on the petitions, then that should be the next question. So under the circumstances, commissioners, I would suggest that we kind of resolve that question so we don't have the staff spinning its wheels really at
An additional point would be that if we put off that decision, we're going to want to ask potentially all these lawyers to come back, and they may want to speak again on the point and answer questions on the point. I believe that Professor Blumstein does make a good point to at least figure out which election we think is the appropriate election. I know it's not something that we've done very often, but I don't think we have this discussion at all very often.
I'm willing to amend my motion, but I just want to be clear that this could have precedential effect for how we act in the future.
I understand.
Okay.
Yes.
In that case, I'll amend my motion that we move I guess I'll withdraw my motion at this
Okay.
point. I'll withdraw my motion.
All right. Yes, sir.
You know, I'm trying to, caution on the right side of this. If there is some deficiencies in our ability to count this or the way we've counted, shouldn't we get it right to begin with? Shouldn't we go back and check if there are some dittos like that so we can be correct? And I understand what Professor Blumstein is saying, but we want to get it right if we're going to move forward or whatever we're going to do.
Let me ask you this. What are the commissioners' availability for the rest of this week, let's say Wednesday or Thursday?
I'm available after 5 on Wednesday and all day Thursday. And if I could just bring up one more point, if we're going to be going back and checking these things and looking at them, if somebody, perhaps Professor Blumstein, could maybe get an answer on the signatures on the back page issue, that is something that I really would like to try to get to the bottom of the best we can. And if the staff is going to be going through and looking again at each petition to see if it has the ditto issue or any other issues, if we could also just kind of keep track of how many of those signatures were on the back page. I wouldn't ask for it otherwise, but if we're already going back and looking at them, it seems like that might make some sense.
Chair, please.
Yes.
Mr. Chair, if I may respond
Yeah.
to Mr. Starling, I completely agree that we have to get the signatures right, but I think we should know how many signatures are required beforehand so that we don't waste our time, or that the commissioners and the staff doesn't waste their time. If the commission decides not to follow my analysis and take a different pathway, that's the commission's decision to make. But now's the time to make that decision, because if the larger number is required, then we can go back and review this in a more leisurely manner to see whether the process is in place or not. It's a different issue. It's less time compressed and less difficult. So I don't disagree with your point. It's just the timing and the compression will take a lot of pressure off to have a little more time to do that.
Okay, thank you.
Commissioner Davis?
Professor Blumstein kind of said exactly what I was about to say. I think you might have to, at this point in time, separate the issues. Whether we probably do need to up and down the November or the August issue in regards to numbers, and therefore that will either solve or give now AOC the time to do what he needs to do, whether it's compressed or, leisurely. I totally concur. We do need to get it right.
I agree that let's say we decide that 30,000 votes or 31,000 votes is necessary, that stops all kinds of stuff we're doing, hiring lawyers, paying lawyers, et cetera. And if we decide the other way for the lower number, then we know we've got to go through all those steps. So I do think Professor Blumstein has made a good point that even though it's not something we do often, in this particular case, it might be more efficient to call a question on which election is the one that we should be looking at.
And, I'm willing to, concede to that point. I just want to make sure that will we still go over the process of making sure. I just don't want to leave that process. If we made an error, we go over and make sure we correct that, right?
Would everyone be in agreement that we make a motion to determine which election is the pertinent election, but that we at the same time direct the staff to double check the numbers to make sure that we have the correct number, the precise number, whether it's whatever it is, to address the concerns that we've raised to get the right number.
Is that your motion?
Yes. Well, let me.
Question.
I haven't made it yet. I guess
Before you
I'm
make the motion, let me make a
looking for a
question
consensus.
Just out, obviously, the two of you know legal more better than some of us here. Would it be better if we did that separate for context of if this comes back up? So in other words, one for the November or August, motion 1, up or down. Motion 2, direct AOC to do another analysis and double check all the votes that we all talked about, just as a point of order. Is that, I'm just asking from a legal standpoint, since you two know better than I. It would sound like you would make 2 motions instead of 1. It's irrelevant to me. I'm just asking.
I don't really have a preference. I'll leave that to the discretion of the chair.
I don't, yeah. Okay, with that,
To me, that makes a lot of sense. To me, that makes a lot of sense.
Okay, all right.
Mr. Chairman, could I make the motion then? Could I
Yes,
make
sir.
a motion that we go back and revisit the signatures to make sure that they are correct in an accurate amount?
Is there a second?
I'll second that motion.
Okay. Any further discussion? We have a motion and a second. All in favor, say aye.
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 Any opposition? The motion carries. Do we have a second motion?
I make a second motion in regards to vote now whether we agree that the August number, which I believe is 12,142, is that correct, AOC?
That's correct.
To be the valid number, I'm saying that right, in regards to legal terms for the continuance of this, in regards to the petition.
Okay,
Now, if I'm not saying that correctly,
Okay.
please help me out there.
all right. No, I think that's satisfactory to call the issue up.
I'll second.
Okay. We have a motion and we have a second. All in favor?
Mr. Chairman?
Yes, sir.
Clarification. What are we voting on now?
What I think we're voting on is Commissioner Davis's motion that the correct number for the number of signatures on this referendum is the number from the August election, which was the 12,142 number.
Mm-hmm.
I believe that's what his motion is. And I believe that's what Commissioner Hertzfeld seconded, but Commissioner, if you want to withdraw your second based on my explanation.
No, I don't want to withdraw it. I think we might be able to phrase it a little bit simpler, if I may.
Are you?
Please, suggestion.
Okay.
Great.
Commissioner Davis accepts a requested amendment.
Okay, great. Perhaps we could amend it to say that we are moving, that you are moving to determine that the August election is the election that is appropriate to measure the number of signatures for this referendum. Does that sound clear?
So I guess now I'm asking a question now. In saying the language in that way, is that binding the commission to that number, or is that just a suggestion for the counting of the votes that we're asking AOC to do?
I don't think I understand your question. I think my understanding is My understanding is what we're doing at this point, we've already said the counting of the numbers will go forward.
Correct.
That's already been determined. So my understanding is what we're doing right now is making a determination of whether the number of required signatures come from the August election, which would be 12,142. And if it's not, then the second motion would be that the appropriate election, as I think you had suggested, Commissioner, the second motion then at that point would be for the November election at 31,212 if the first one were to fail.
Well, I'm only making one motion. I'm
Understood.
only making one motion in regards to August. So
Just for August.
So I guess the correct statement would be I'm making a motion that the Election Commission say that the August election of 12,142 is the appropriate number for the counting of the number of signatures on the petition.
Correct, and I will second that motion.
Any further discussion? We have a motion and a second. All in favor say aye.
Aye.
Any opposition? With no opposition, the motion carries. Is there anything further? On agenda item 3.
I don't believe so, Mr. Chair.
Okay. Now, we come to agenda item 4, retention of counsel. Professor Blumstein, do you have, can you give us a report on the status from your perspective on that issue?
Thank you. Appreciate it. As everyone knows, I was retained just for purposes of determining which the right election was, and the commission has now voted on that, which I appreciate. There will be further proceedings, and now there'll be a testing of the validity of the signatures. And then Director Cooper, in his opinion and in his earlier submission, raised a series of questions about the petition, its clarity, and so forth, whether it conforms to the law. And I think that will needs to come before the commission in another meeting. And my understanding is also there is litigation, and the commission needs to have a lawyer in order to respond to any litigation, even if Mr. Roberts, as I would ask him to do if I'm retained here, I would ask him to withdraw his litigation. And apparently it's been put off for a couple weeks. So there'll be time for him to withdraw the litigation, which I think is premature at this point, and I would certainly ask him to do that if I were the lawyer. And so as I understand it, the next kind of phase is that what Chair Delanis and I were talking about was to do this in phases, that I would be retained as the lawyer for the commission, but then the fee structure would be based upon a phasing, how much per phase. And I'm not really used to doing it this way, although I have done it, but he has a strong preference that there be a fixed fee rather than an hourly billing. And so I would agree to doing that, but we both agree that a number higher than what I've just done, because what I've just done is a discrete thing. This is going to require a lot more work to go through this. Also, if litigation doesn't go away with Mr. Roberts, or there has to be other fact gathering and analysis, I'm a law professor by day and by night, and I need to have some backup, as Dean Koch had. And so the same idea would be that I would have the authority to retain someone, and he has suggested Austin McMullen, who has litigated these cases, some of these cases. And I've spoken with Mr. McMullen. He has put forth a proposal, and that basically I would recommend to the commission that I be retained on a fixed fee basis, and that Mr. McMullen and his firm, the Bradley firm, be retained on an hourly basis in accordance with his proposal, so that his rates would be tiered. His rates would be set at a certain level, as he mentioned in his letter, and then associates and others would have a lower hourly rate, so that they would be billing by the hour, and that would also allow me to call upon him as needed, and I would monitor the time so that it wouldn't be out of line. I would feel comfortable, and that I would not have any incentive to bill more time because I'd be on a fixed fee basis. I have to say that every time that I've done this, I've always spent more time than I've anticipated. And that's true of this representation as well. But I'm glad to do it. It's a part of a public service. And the number that I think is fair, we had 15,000 for this representation. The next part is going to be more time. And so I was thinking 25,000 would be the right number for me. And then Mr. McMullen's time would be in addition to that. So based upon the hourly rate that he specified in his letter to the commission. So, Mr. Chair, that's kind of where I am. I don't know if that's clear, but that would be for proceedings through the commission stage, not through litigation, if there is litigation, but through the commissions, the next commission stage, in which all the concerns that Metro has put forward would have to be addressed, and the validity of signatures issue would have to be addressed. So that's kind of where we are. I hope that is clear to the members of the commission.
And you've met or discussed with Mr. McMullen these issues? You've talked to him about all of these things.
He has told me that he would agree to that based upon the rates set forth in his letter to the commission earlier. I think his rate would be the highest, but the others in his firm would be lower. And so it would be up to me to monitor that, but that's basically what we talked about.
And in order to complete the steps to engage you and Mr. McMullen, what are the next steps? What would we have to do to verify or firm up all this?
Yeah, well, I think you'd have to do what you did in the initial retention vote, which is to vote to retain me at a flat fee of $25,000 for proceedings in the commission up to the commission's determination whether to put these matters on the ballot, and authorize me to retain the Bradley firm, and specifically Austin McMullen, who was recommended to me, to assist me, and for us to agree. I can't specify about who's going to do what right now because we don't know exactly what we have to do, but to agree on a fair allocation of work so that I can have them do as much as they can do, and I'll do what I have to do, and I'll oversee the whole process.
Do the other commissioners have questions?
I actually have quite a few. Sure. You've referenced now a couple of times the letter that Mr. McMullen sent to the commission. I don't believe I've seen a letter from Mr. McMullen.
I think I handed it out at one of the meetings. It's in with his credentials. I thought I did, and there's some hourly rates there.
I don't recall seeing that.
Okay, I'm sorry. I can get it to you, but I'm not. Well, I'll tell you what. You continue to ask questions.
I can tell you what his
go through my bag here, and I might have it.
Perfect.
Okay.
Okay. I also have a couple of other questions because I actually was the one who made the motion for your representation last time. So I just wanted to clear a couple things up. And looking at the memo that you had provided to us, I see that the last sentence in the first paragraph, obviously talks about the fact that you were retained to give us an opinion on the numerosity issue, as we've called it. But then it also says that the scope of your representation was limited by, it looks like some sort of communication that I'm assuming was from the chair that said specifically it does, quote, not entail research outside of Tennessee or any additional research of Tennessee authorities beyond those cited by Misters Cooper and Koch in connection with the signature issue in their two recent memos dated April 2nd, April 6th, 2021, respectively. And when I had made my motion for the retention, I certainly did not limit the scope of where you were to look and what authority you were to consult. in that manner. And so I just think perhaps there's been a bit of a probably communication issue because things have been moving very quickly, that you were probably communicating directly with the chair in order to get a retention agreement signed and those types of things. And I understand how things have been moving very quickly. So I understand how that happened. But I would like to be clear moving forward, and I think you've said this already, that, if you were to take on representation further in this matter, that you would be representing all members of the commission and not just one person or, a particular viewpoint or party. So I'd like to make sure that we all get the copies of communications and emails and letters and retention agreements and those types of things, just so I can keep an eye on making sure I understand what we're getting.
Yeah, that's a fair question. I don't think that that anything would change based upon that limitation.
And I agree with you because I've done the research myself. It was just something I wanted to flag as a potential issue.
But it was put in part for my comfort level.
Okay.
Because I was agreeing without knowing what was expected of me in terms of time. If I had to do a lot more work, I probably would have asked for a little bit more of a retainer. But with that constraint, I was willing to take the risk, so to speak. And even so, I've spent a lot more time than I thought I would, which is fine. I mean, this happens all the time. But, I live at the law school, and they let me out once in a while to do these things. And so I was just not comfortable having a universal, reinventing the wheel. But for this next representation, that restriction would not be there.
And really, my only concern is making sure that the other members of the commission are included on those types of communications so that we can see them and know. I'm not actually fussing with anybody about the actual terms. I just was unaware of it and surprised to find it, considering I'm the one who made the motion. And so I just was a little surprised. But again, I think we were just moving very quickly. The other issue that I have is, I think I had raised this issue at the last meeting, is that we already have a set of lawyers who are representing us in the first lawsuit having to do with the petition that is still ongoing. And my understanding is that Justice Koch has withdrawn his representation from that. And so our only remaining attorney in that litigation would be Janad Odebeko, who's also at Bradley. Now, I think the public and this commission and everyone knows that we've paid a substantial amount of money to Justice Koch and the Bradley firm already to get sped up on these issues of whether the terms of the petition, the last petition, were appropriate for inclusion on the ballot. And I think there's a lot of crossover between those issues, the legal issues, the cases that one cites, and the specific language. So I'm happy to continue with the Bradley firm, but I keep only hearing the name of Austin McMullen, who was not involved in that litigation, and not Mr. Odebeko. I don't quite understand why we would switch lawyers and have literally one lawyer from a law firm representing us in one case and another lawyer from that same law firm representing us in another matter, when probably 85% of what's going on actually crosses over both, specifically when the commission has already paid that first lawyer to get up to speed. And I'm not trying to be critical of anybody in particular. Mr. McMullen's a fine lawyer, and I think Mr. Odebeko's a fine lawyer, and obviously I believe Justice Koch is, and you as well, Professor Blumstein. I just, at this point, feel like we have a whole lot of lawyers for a whole lot of litigation because we chose not to have Metro Legal, who would have been free to us. Perhaps there was a conflict, or there wouldn't have been, and it would have developed at some time. But now we're on lawyer. If you count Metro Legal, that's 1. Mr. Odebeko, that's 2. Mr. Koch, that's 3. Professor Blumstein, that's 4. And then if you get to Mr. McMullen, that's 5, 2 of which are at the same law firm that we've already paid for. So I have some concerns that we're double paying the Bradley law firm to get up to speed on an issue that we've already paid the Bradley law firm to get up to speed on. So that would be my concern. And again, I'm not exactly sure how to put a cap on it at this point, but and I do have to say, I'm going to say all my concerns. $25,000 is a flat fee, and I understand that, and I get it, but that is only going to take us up until we make a determination as a commission, and then we're going to have to vote again, correct? If it ends
I
up,
didn't hear that last.
the $25,000 flat fee would only take us until we make a decision whether or not to put the issue on the ballot as a commission.
Yes,
But that doesn't include any litigation we actually have going on right now.
correct.
So this,
Well, let me just say, if I am the legal counsel, I would have to get myself up to speed. I assume that I would stand in the shoes of where Dean Koch was. And in terms of who would assist me, Austin McMullen was a student of mine, but I don't know him. I've had conversations with him. He was recommended to me. He was involved, I guess, on the other side in the FOP litigation. So he's aware of these issues. I mean, he's immersed in the issues. And I would think that it's just a new team, and I don't know that how much duplicate. I'd have to talk to Austin about that, but I don't know the other lawyer. I would have to feel comfortable, whoever it is, and I've spoken to him, and I'm comfortable with him, and the chair has spoken to me about him, and so he was not my original choice or non-choice. It was nothing, but he's knowledgeable about this. He's expressed an interest and so forth. So I think it's a reasonable choice. Would I oppose dealing with the past lawyer at Bradley? I don't know that lawyer really, and I don't know that we have to be compatible, and we have to have the same kind of focus upon how to approach a problem. And I've had a pretty extensive conversation with Mr. McMullen, so that I have become comfortable that working relationship would be good. I don't think there'll be a lot of overlap. I really don't, but I can't say there won't be any. Commissioner, I just can't say there'll be no overlap.
So
On the other hand, there'll be some getting used to things, maybe a different approach and so forth to how we litigate and how we approach things. I don't know with the existing Bradley counsel. I just don't know that. So
I think my other concern, though, is that the $25,000 doesn't include the actual litigation.
that's correct.
And we have litigation pending right now where we have no lawyer.
Well, it doesn't account for litigation, but it does account. There would have to be if we have litigation matters, we would be your lawyer. We would have to come back to you about some fee arrangement for that litigation piece. We would be responsible for the litigation at some point. The unknown question is how the fee arrangement would be. And since Chairman Delanis wants me to do this on a basis of fixed fees, I just can't be in a position of saying, here's a global number. It'll have to be kind of phased in. So I don't think the commission will be disadvantaged. What would happen, Commissioner Hertzfeld, is, well, if the litigation heats up, if the commission is sued, or if the Roberts matter continues on, if we can't settle it or make it go away, which would be nice if we could make, I actually have to be kind of schooled in what's left in that litigation. I thought it was not appealed. I'm not aware of where that is in the cycle, but I would take over for where Judge Koch was or Dean Koch was, and I'd have to be brought up to speed. But to the extent that there's litigation dimensions, I would take responsibility, but I would present the commission with a set of fee terms for that discrete activity. I just can't fold in an all-in number that would say this covers litigation, this covers commission work and so forth, because I just don't know what's involved, and I don't think it would be reasonable to ask me to give a global number at this point. It's too soon.
And so I'm wondering if perhaps the more traditional approach of an hourly rate would be the better way to go. I mean, we've got currently 2 lawsuits against us. I just want to make sure that I'm getting this correct. We have 2 pending lawsuits about the various petitions against us in Chancery Court. One is the previous petition where there's some open meetings issues that are left and maybe some sort of constitutional due process issue. I don't really recall what it is, okay? But there's some appellate issues and some kind of lingering issues on the first petition, if I understand correctly. Is that your understanding, Mr. Delanis?
Yes.
Okay.
There are some settlement talks ongoing, and I'm hopeful that Mr. Odebiku can give us a report in the next week.
Okay, so we have Mr. Odebiku on that case, so we don't need new attorneys on that case. That case is handled.
I don't believe so.
Okay.
I don't believe so.
So then the second case that we have right now is the ballot signature issue that Mr. Roberts has filed a lawsuit on, and that does not have to do with the substance of this particular petition. Is that right?
Correct.
So I think,
The hearing has been put off till May 4th.
and we do not have a lawyer in that case.
We do not have a lawyer, no question about that.
Okay, and then so far as I can tell, it looks like we will probably have a third lawsuit, or at least another issue raised in that second lawsuit, depending on whether we get sued by Metro or vote to put it on or vote to take it off. No matter what we do, we're going to get sued. So that's a potential third lawsuit. So we have representation by Mr. Odebiku at Bradley in the first one, and that will remain the same so far as everyone is concerned, and potentially that will be settled.
I mean, unless somebody makes a motion, I have no issue personally with Mr. Odebiku continuing at all.
I think my concern is that what we're being asked to do now is to pay a flat fee of $25,000, which I appreciate trying to do it as a flat fee. This isn't critical. I'm just trying to figure it out. We have a flat fee of $25,000 that doesn't cover us for the second lawsuit that we have pending in Chancery Court, with now a hearing that we thought was this Wednesday, but now is May 5th. And this other issue that we know is coming. So, I mean, suffice it to say, this could be very expensive. There's going to be a lot of lawyers. It's going to take a lot of hours. And, we've hired very, very, very qualified lawyers. And so rightfully, they charge a lot of money. I just am not sure that we're going to have the ability to be as nimble as we want to be if we're doing this in a phased approach of $15,000 for this, $25,000 for this, and, we're going to need somebody to be in that second case we've got right now. I think it would be nearly impossible for Professor Blumstein to give us a flat fee for that litigation.
Yeah. Can I respond to that, Commissioner Hertzfeld? I view the past as the past. I don't know that I have anything really to say. But going forward, we do have the litigation, the Roberts litigation. If the commission has now voted on which is the right election, and I would view myself and Austin McMullen as having responsibility if that litigation stays in place, or if Metro sues, to represent the commission. The only thing is, Chair Delanis and I, and Mr. McMahon and I would have to discuss what the fee arrangement would be for that piece. That doesn't mean we're going to walk away or not represent. It's just that the compensation, since it's a fixed fee, I think it's in everyone's interest to know what the scope and the parameters of that fee cover. And so if it goes beyond that scope and the parameters, then the representation and the intent would be to still to represent, but then to kind of talk about what makes sense from a fee perspective for the next phase. And even there, if it's the Roberts suit, it may be that would be a relatively small commitment of time if in fact the commission, in a sense, accepts his position on as it has on the numerosity issue, but also if it turns out that the signatures are there. If the signatures, based upon what the staff says, are not there, and the commission decides not to go forward on that basis, then there may be a suit, but there may not be a suit. So I think I just can't give you the certainty that you want about litigation, except the commitment that I'm not going to leave the commission high and dry, and neither will Austin
And I appreciate that. I think maybe my suggestion, and then if I have a suggestion that maybe will clear this up. I understand having the distinctions, and I get that, and, you know, representing us through this next phase on the commission. I think that's very smart. But perhaps at our next meeting, we could have a fulsome discussion about, you know, whether we're going to do an hourly basis. I feel like we really need to be covered on this litigation, and I think that's a very urgent scenario. And I think it's going to get a lot bigger and a lot more intense than, you know, folks are probably even anticipating at this point. And so my thoughts are not a criticism. It's more of trying to be prepared for what I think is going to be a barrage of very heavy litigation with very quick timelines very quickly. And I'm very uncomfortable with the fact that this commission is bare on representation at this point.
Yeah, and the commission should have some indication of, because they were paying lawyers' fees for the last go-round. One thing I might ask is for commission staff to kind of go through the records after they look at the validity of the signatures, but to go through the records and see how many hours were spent before Chancellor Lyle in that proceeding last time. That would give us something to benchmark from.
So perhaps if we could just come at the next meeting, be prepared to have a conversation about getting representation so we are covered in this litigation and future litigation involving this petition, then I think I can probably move on to something else.
Okay. Let me address some of the points you raised. All good points. I mean, I think we're all equally concerned about not having a lawyer in an ongoing case. And now I have spoken to Mr. McMullen about his knowledge of the first case. And as I understand it, both he and Mr. Odebiku work in the same area. They've talked about these cases. Both of them have talked together about both of those cases. You may not see their names billed on the file, but Mr. McMullen is aware of the first case and was, I believe, consulted about the first case. So I won't say he's completely up to speed, but I mean, he is aware of the case and of the issues, and he has experience with these kinds of cases. While the issues are the same, the current referendum, I think, still is significantly different than the one we saw last year. I do think that regardless of who we hire, it's going to require some substantial work to address the new issues. But I take it do you want me to address let me ask you this, what kind of authority do I have in the next couple of days to come back and give a report?
I think the questions that I kind of have is I'd like a proposal from Professor Blumstein about what, you know, he thinks litigation would look like, and if he could do that on a flat fee or it would be an hourly basis. I also think that, you know, I know he'll be very good about giving us, you know, routine reports, but I think as a commission, we should probably be just looking at hours semi-regularly to kind of know where we're at, so we have an idea of kind of what our hours are, just so we have an idea. Not that that's going to stop anybody from doing the work that you need to do, but I think we should probably be reviewing it. But I do have to tell you, and I've said this, and I'm going to say it 100 times, I have significant concerns about choosing another lawyer at the same law firm for, you know, what is sister litigation. I'm not going to stand in anyone's way if that's what Professor Blumstein thinks is, you know, necessary for him to do his job to the best of his ability. But if you're going to speak to somebody at Bradley, I would certainly feel more comfortable if we can be sure that Mr. Odebiku is not, and I think we talked about this before, not excluded from this new litigation. And I'd prefer what we do is hire Bradley as General Bradley and not a particular lawyer at Bradley, and let Bradley figure out, you know, how that is. Because I think we need to really save the taxpayer dollars that they've already invested with lawyers at Bradley to deal with these petition election issues. So if you could maybe negotiate that and kind of come back, I think that would make me feel a bit more comfortable.
Okay, all right.
How active is the first attorney now that you guys hired, I guess, last year? What's the gentleman's name?
Junad Odabiku?
Yes, yes.
That case has been quiet for a long time, but recently some discovery requests were served by Jim Roberts, which have led to some settlement discussions along the lines of Mr. Roberts dismissing his case and both sides just walking away. I think that's at least what we'd like to present to the commission, and I think it would be known that the commission would have to approve that. But that's, I think, what's being discussed. There's no way of telling whether that will be successful, but also to address a point you raised, much of the work at firms like the Bradley firm are done by people below Mr. Odabiku and below Mr. McMullen. And I think those people obviously are going to be involved in this case, the same ones that did the legal research and the drafts, initial drafts of the briefs and like that. So I think we can achieve efficiencies that way. Is that kind of what you were thinking about?
That's really getting to my point. So again,
Sure.
I think if we can phrase this more as hiring the Bradley law firm to assist, you know, as opposed to a particular partner, because I think that's what's really, that's really the rub for me, because we've already paid for one partner there. So if we could hire Bradley and let Bradley make the decisions from an efficiency basis as a client, as they would, clients always, you know, or as I guess they're the attorney, we're the client. You know, obviously they have an obligation to try to, you know, not double up on things and to be as efficient where they can. And I trust the Bradley firm to make sure that they are doing that. So that would be my request.
Okay. All right. Is there any other comment or input?
I have no objection. The only thing I would like to be sure is that the relationship is such that you would be retaining me, and then I would be retaining them on behalf of the commission, so that it's clear where the leadership lies. And so that was pretty clear, as I understand it, with the relationship between Bradley and Dean Koch. And so, you know, I also didn't want to press that point too hard, because Austin has been out 23 years, and he deserves to have respect for all the time and expertise that he has. And so I didn't really want to make that a central point of our discussion. But I think in terms of understanding for the commission, that I would be the point of contact for the commission, and then I would manage the legal team that would include Bradley as well.
And I understand that, and you know, I don't necessarily have an objection to that, and I'm certainly not trying to diminish the qualifications of Mr. McMullen, but I will also point out that Mr. Odabiku teaches election law at Vanderbilt Law School, is my understanding, so, or has at, you know, at some point. You know, Mr. Odabiku also is a very highly qualified lawyer who I've known for a very long time, and what I don't want to be doing here is saying, you know, somehow that, you know, one attorney at Bradley is somehow preferable to another. I think if you have a preference on who you work with at Bradley, you know, I leave that to your professional discretion, but I don't really think that that's something that the commission should be getting in the middle of.
Should or should not be?
Should not. We've already paid the money to Bradley to get up to speed.
That suits me fine, is that I think, you know, I didn't know what the lay of the land was, and I didn't know if the other lawyer at Bradley who worked with Dean Koch, and is he one of our graduates?
Yes, I believe he is.
Yeah, I don't think he was one of my students.
I think that's probably true.
I don't know him. But that, I don't, you know, Mr. McMullen was one of my students, but it's 24 years ago. I don't remember him particularly well. I've had the conversation. He expressed an interest, but I think what you're saying makes some sense, good sense, that that would be up to me. And in the pandemic, this will be a new thing. I don't actually get out to talk to people, even though I've been teaching in public. This is one of the few times I've actually been to a public meeting. But, you know, I'm all vaccinated and so forth, and I'm willing to kind of do that. But I think it would make sense to have either a Zoom meeting or a facial meeting where I would talk, since I've talked to Austin, to talk to him. And I wasn't sure, you know, whether the prior relationship was still good or not so good. If it's fine, then we would try to work with Bradley, and then Austin and the other gentleman would be, you know, partners together in a firm, and they'd have to figure it out themselves. And to the extent that I thought one brought a little more to the table on one issue and another, that would be something that I would have to kind of navigate.
That would be absolutely fine. I think we understand each other.
Okay. Okay.
And can I just ask one more question? And so the $25,000 would be representing us kind of through, you know, the decision we make on whether to put it on the ballot or not. But what does that entail? Is that another memo and appearing at another meeting, or what's included in that $25,000?
We haven't really talked about that in detail. I would assume the memo was my preference, because I thought talking to everybody was really important, but having a piece of paper document in place was important too. And I can't really say, I'm guessing that some issues will warrant a memo and some issues won't. But Commissioner Hertzfeld, I just don't, I can't give you as good an answer as I would like to give you on that, because I have not looked at the lay of the land going forward. But there are some issues in which we may want to respond. Metro, you know, I've known Bob Cooper, here he is. He won't mind if I flatter him a little bit. I mean, he's a terrific lawyer, and he's a very smart person, and he's made some arguments. Some, as I said in my memo, I agree with. Some I may disagree with. These are all going forward issues. And so if there's a sophisticated or subtle issue that Metro Legal has taken a position on, I may think that more than just an oral response is really indicated.
And I'm happy with the memo. I don't mean to interrupt you, but I just want to be clear. So when we're saying $25,000 to represent the commission kind of through this conclusion of whether it goes on the ballot or not, that would be only you. We would not be in addition paying Bradley.
No, you would be paying Bradley in addition. The $25,000 would be a flat fee for me, and then Bradley would be whatever Bradley bills.
Okay, so I guess, so I think my understanding is when we were talking about bringing on Bradley, I thought we would be talking about doing that in the context of the litigation that we have going on. I do have a pretty significant concern then, because if Bradley is also kind of speeding up and going to be involved in it, then the fee to the commission is going to be, you know, certainly in excess of $25,000 without having any representation for litigation at all.
Well, no, I think that we will not have agreed on a fee structure for the litigation, but I'm assuming you're not going to change lawyers for the litigation.
No, and I agree, and I don't mean to interrupt you. I just want to be, I want to be clear that, so what we're talking about right now is getting representation, so we have people to tell us what the law is on whether the petition should go to the voters or not in a more substantive capacity than just the numerosity issue. Yes. Okay. And so on that issue, we are essentially going to get some meetings, some research, a memo coming to the next however many meetings we have. I mean, those are the types of things that would be involved in that.
Yes.
But in order to do that, Professor Blumstein is saying he will do a $25,000 flat fee, so we don't have to worry about hourly. But in addition to that, we would be hiring Bradley to assist him through that process. So it's going to certainly cost us more than $25,000 to get to the end of this issue of whether it goes onto the ballot or not.
Yes, no question.
I think there's no way around that, because I can't, I'm willing to take a flat fee for my time, but I can't do it all.
I understood. So I actually think the flat fee in this circumstance, I got to tell you, that seems like a whole lot of money to me to do $25,000 in addition to Bradley's rates, which I'm sure are not, you know, super cheap, to kind of get through the next thing. I'm not sure we're not better off doing an hourly basis.
Question. So I understand. So you are okay with Professor Blumstein, yes or no?
In general, yes. I mean,
Okay.
I voted for him last time.
Right.
I've
Second
known him for, I don't know, how many years at this point? Yes.
Right. So second question that you have, just for clarity and point of order, is that you're concerned if he will be our lawyer, the commission's lawyer, through this process and going forward, if into going to court, in the courtroom, over potential lawsuits that may come.
No, I don't have that concern. I think we'll deal with the litigation issue as we will with the new, as we've talked about at the next meeting, we'll have a conversation about litigation.
So your concern, my third question is, your concern is that, do we pay him on a flat fee or do we pay him on an hourly fee?
Yeah, my concern right now is that we have $25,000 plus an unknown number to get us through this next section, which does not even get us to litigation yet.
So the next question is, you want to know what that extra number is.
Or just to hire, I think, or to hire everybody hourly and just say, here are the hours, and that way we can look at each hour and say, okay, you know, this is this and this is that. I think when we're doing a hybrid of flat fee and hourly, I get the notion for doing flat fee. That's to have certainty and to know, and sometimes you bet and you win, and sometimes you bet and you lose, and that's how a flat fee works. And I get that, and I understand wanting to do that from your perspective, and from our perspective, I think it's a, you know, that's a good way to, you know, try to make things certain. But when you put that with a hybrid of also an hourly, I think you lose the benefit of doing kind of a flat fee at that point. So I would suggest that it either be a flat fee for Bradley and Professor Blumstein, and we just call it, or that we do hourly for everyone.
Well, I guess, and if you would indulge me momentarily, I guess that was part of the giving him the carte blanche to direct his work as necessary. Therefore, because he was so kind to actually do a flat fee for us, which is not his normal operations, if I've understood from what he said, and to get someone that you even recommended, you know, giving him the leeway to do what he needs to do, I think there might be some, although there is going to be a cost, there have been a cost whether it was Blumstein or it was Koch, either one, there's still going to be representation that they used that we would have to pay for regardless, correct?
No, I mean, I understand that. I think the issue is we have absolutely no idea how much this very limited representation is going to cost us. And it's very limited. It doesn't take us through to the litigation, which is where the money's really going to start. Like, we're really going to get charged when you start getting lawyers for
Right, and that's
litigation.
why I asked you the question, were you concerned about that being going forward? That was my first question.
I don't think I quite understand your point. Am I concerned about the cost of having legal counsel in general? Yes, for litigation, for this point, all of those things. Typically, we have Metro Legal that would advise us, and so we don't pay for every opinion that we get, every question that we have, we don't have to pay for that. And I understand that we need to in this circumstance because we've gotten separate counsel. I think my concern is, it sounds like we're going to be paying a lot of money for like a very limited amount. I understood the $25,000 to include whatever Bradley would be doing as well. And I think that is my concern, because now it's $25,000 plus.
Well, I think, so, Chairman.
I think everybody understands the concern about attorney's fees. Can you give me the authority to try to take these issues to the lawyers involved and see what I can do to put some parameters on it?
Yes,
and I know
Chair.
it will be hard to put an absolute clamp on it, but to put some parameters on it so at least we know if we're getting beyond a certain point,
Yes.
so that like any other client, you'll know, well, wait a minute, this is getting to a point where it's going to hurt.
I think that sounds like a great idea.
Okay. Do you see what we're talking
Yeah,
about?
I think you could put some parameters around that and kind of box it in a little bit, and then know, kind of what the cost is going to be, based upon that, right?
Well, we can try. I don't think there's an absolute way, but at least we can get to the point where there's a report being given to say, okay, hey, wait a minute, this is where we are right now. and this is what we think is going to happen in the future. But I need to kind of warn everybody that a lot of times the lawyers have no idea what the other side in the case is working on. For instance, Mr. Cooper is up late at night thinking of things that he's going to argue that we may not have thought of yet. So it is difficult in the adversarial process to come up with a flat number. And that's why I was pleased that Professor Blumstein has been willing to do that, although I recognize the issue that Commissioner Hertzfeld has raised, which is, okay, we are trying to get the best of both worlds over here, but maybe we're getting the worst of both worlds. So I have to try to work that. And the last time I sometimes have problems trying to figure out what I can communicate and what I can't communicate under the open meetings law. And I did think we had an understanding that Professor Blumstein's research was going to be limited. And then I talked to him about the way he wanted to limit it. But I understand your concerns, because, you want to know what's going on.
Yeah.
And at that point, we didn't have time to have another meeting.
Right.
So since we're going to have another meeting, hopefully in the next couple of days, that will not be a problem this time.
That sounds great. Thank you for addressing my concerns, Mr. Chair.
Mr. Chairman and Commissioners, let me also say that since the Bradley firm will be working in a way, I want to choose my words here carefully, but in assisting my work, really, that part of my responsibility to the commission is to oversee what time they have in this, and that they push the work down to the lowest cost lawyer that can do the job and so forth. And but I can't promise a number, and I can't say the whole thing is done for the 25. I just can't do that.
Understood.
I just can't do that. Okay. But I'm willing to take the risk. And, managing this in the way you're describing means more time. I can just see my time. So I've just taken on another task here in a sense of managing. And managing lawyers requires delicacy and negotiation and so forth. And so, but I'm going to willing to take that on for the same amount and kind of cap your obligation to me. But that doesn't cap my obligation to you. I'm going to deliver. There's no limit on research or something. This is going to be a full analysis, and we have a full memo now, opinion from Metro Legal, that I haven't done more than skim. So I don't even know, what things. Remember, my obligation to you is not to be in favor or against anything, but to help give you the best advice. Now, it may very well be when I read all these things, I'll conclude that Metro is right about something, and I would advise you of that. Or I may advise you that it's not right about something, and I would advise you about that, as I did on which is the right election. I just am saying that I can't do that all myself.
Appreciate that.
I need to have some support from the law firm.
I appreciate that.
If you want to maintain it with the law firm that you're comfortable with, we can have two partners at the law firm, and then it'll be up to me to negotiate and navigate who's the right responsible person on a particular task or matter. And then I'll get to meet
Mr. Odebeco.
Mr. Oduko, is that?
Mr. Odebeco.
Odebeco, yes. I will, if you vote to retain me at this point, I will probably not till Tuesday, because I have an exam to write between now and Tuesday.
I think I can make I would actually make a motion if it looks like we're going to have another meeting later this week. I'm going to make a motion to move this issue of retention of counsel for this issue to the next regularly scheduled meeting of the Election Commission, or specially called, I guess, meeting of the Election Commission, with the knowledge that Chairman Delanis is going to do some work trying to put some stuff in some stuff in place that can potentially clarify some of those issues, and then we can vote at that time.
Well, you know, again, for my purposes, I'd prefer that Chairman Delannis's initiatives come after the commission votes to hire us. I really would not urge you to put that decision off. I think that, again, I want to get the team in place. I want to have.
I don't think we can until we know how much it's going to cost.
Well, I don't think you're going to know how much it costs in any specific terms. I think the best we can do is to, and the best that Chairman Delannis can do is to put some guidelines around, some reporting requirements and so forth. But you're not going to have a number.
I understood, but I've made my motion. Thank you.
Anyway, I would respectfully request that if you're going to hire our team, that you do it at this meeting if you can. Subject to the various things we've talked about.
Yeah, I mean, I think what Commissioner Hertzfeld is saying is that she is willing to go forward and is telling us she is going to hire, but she doesn't hire you and the team, but she's not comfortable here on the public record without knowing a little bit more about what it's going to cost. And all we have at this point from Mr. McMullen, I think, is his $460 per hour rate. That's the only thing that I have and that he presented to me, and I know you haven't seen it yet, but I think I handed it out at a meeting. Commissioner Hertzfeld.
I'm happy to get it from you after the meeting, Chairman Delannis. It's okay.
Okay, all right. So I think she just wants some parameters to make her comfortable, which is, that's common today, I think, in engagements. Are you willing to go forward for us to discuss some of these issues with Mr. McMullen and you as lead counsel to try to give her some comfort?
Yeah, that's fine.
Okay.
How you want to do it, I'll be fine with.
Okay.
It sounds like it's the Bradley relationship that concerns you. And it may be that you can, again, separate this out. You can retain me as your lead counsel with the understanding that there will be additional legal support, and leave that to consultation between me and the chairman about how that comes. But I'm just saying, Commissioner Hertzfeld, as much as we want to oversee the costs, I will try to make you as comfortable as I can, but I'm not going to falsely give you false comfort that I can tell you what it's going to be. I just don't feel comfortable. I would not be.
Professor Blumstein, I wouldn't ask you to do that. I litigate professionally. So, that's what I do. I know that litigation can take on, all sorts of costs and time. And, there's an issue you suddenly have to brief that you never even knew existed and something else has happened. That's exactly why. It is not a criticism of you. That is exactly why, because I am so familiar with the way that litigation can go and issues can come up, that I want to have some understanding of, some guardrails, some check, as opposed to just saying, yes, Mr. McMullen will pay you $460 an hour for whatever is necessary infinitum until the case is done. This is not a criticism of you. It is not a criticism of Bradley. It is simply just saying I'd like a little bit more information before we do it. That's all.
Okay, and would this be something, Mr. Chairman, that you would want to negotiate? Is it something you would want me to negotiate? Again, if I'm going to negotiate it, I'm very uncomfortable negotiating when I'm not sure that I'm really your person, so to speak.
I'm sorry.
I'm not comfortable negotiating with Bradley or with any other law firm when the commission hasn't voted to move forward and have me be your lawyer. I'm just not.
I think Chairman Delanis, I'm fine with Chairman Delanis negotiating that.
Well, here's what I think. To Professor Bloomfield, I think there's two issues now at hand. I think and if I'm wrong, please interject. The first issue I think we as the Election Commission have to say is, do we want Professor Blumstein to be our legal counsel? That is issue A, regardless of who else he needs to support him, period. Okay? Issue B is, if that is to be the case, what is the structure of fees for whatever support he needs to do his work? That's a separate issue that can be guardrailed according to what, your thought process. But if you don't say he's it, then the rest of this is going out baby in the bathwater, and we're still with no representation and nobody else to do the work. And now we're back to square one.
But you can't hire someone without an agreement. You have to have an agreement in order to retain counsel. And my point is, until we get this figured out, I'm not comfortable saying flat fee for Mr. Blumstein plus until we have some guardrails. I also want to be clear, if I can just finish my point. Today is Saturday. We're trying to hopefully set a meeting for Thursday. Professor Blumstein has an exam he's got to write on Tuesday. I mean, clearly we're going to be moving forward in some capacity. I just don't see why we can't put this off a couple of days to get it figured out, because we are dealing with taxpayer money, and it's going to be a lot of it. It's going to be a whole lot of it. And so I just think that it's not throwing the baby out with the bathwater. I think it's taking a pause to make sure that we're being as fiscally responsible with the taxpayer dollars that we can, and we're not losing a lot because we don't have a hearing set on Wednesday anymore. It's no longer set until May 5th. I'm not saying I have any objection to any of these lawyers, and I want to be clear. I think I've said that from the last meeting too. I'm not saying I have an objection with the lawyers. I just want to make sure that we are staying as fiscally responsible as we can on the front end, so we don't end up with a $500,000 bill on the back end, and we have to go tell the taxpayers, well, we said, and so it's $500,000.
Right, I agree. And I think I have no issue with the fiscal responsibility issue. I'm glad you brought that up. However, with that fiscal responsibility, we have to say, do we want him as counsel or no before we even go there? And you've been saying the whole time that you were very comfortable with him. And I think that's been his main concern in this whole 20 minutes that we've talked. Is he going to be the legal counsel going forward? And we've already agreed to this fee that got us this far today, and he's already said that he is willing to continue on, and that's why I'm just bringing that as a point of order, because I think that's his concern at the moment in time.
If we move forward today, I mean, if we're going to call the vote to retain Professor Blumstein today, I'll be withdrawing my support for moving forward with Professor Blumstein. So I just want to be clear where we are.
Okay, I have a suggestion. What about retaining Professor Blumstein and subject to his coming back to the commission with basically a support and with a support firm, and having the parameters of the engagement of the support subject obviously to the commission's agreement.
I'm sorry, I can't support that. I can't support going forward with a $25,000 fee without knowing what else there is that's out there and what that's going to look like. And again, if you give me a few days, I can perhaps be supportive of this entire arrangement. But today, I cannot move forward in making that commitment without knowing the other information. And I apologize for that. That's no reflection on you, Professor Blumstein. It's just where I'm at financially.
Mr. Chairman, can I?
Yes.
I think that Mr. Davis captured the point. Commissioner Hertzfeld, what would you like to see? I mean, as I understand it, my marching orders, if I'm retained, would be, okay, you're going to do what you do, but you can't do it all. You're going to bring in the Bradley firm or, some other firm, but let's assume the Bradley firm, that suits me fine. we're going to have a mixture of the previous Bradley lawyer and the new one, and we'll figure out how to make that work together. And so presumably, and I've talked to Austin about this, about what guardrails or parameters he would be willing to accept. And I can't really negotiate because I don't have authority to negotiate. Until the commission retains me, I don't have the power or the authority. I can't tell him, cut your rate or cap your rate or do this, and then we'll be okay, because that's not true. I can't. And until I can assure him of an outcome, I'm not going to be able to do the best I can on behalf of the commission. I have to have some assurance that I can deliver on my end if he's going to deliver on his end. And that, you know how that negotiations are, Commissioner Hertzfeld.
I do, but I also know that people negotiate and put proposals all the time before they actually have been retained to do it. People make proposals. People make proposals all the time on how they're going to represent someone before they're actually retained to do it. I understand the issue here, but a mixed, getting the benefit of the bargain, I'd like a little bit more time to get this information moving forward. It's just where I am. So if you all want to take the vote and, if you've got the votes to go ahead and do it, it'll be over my objection.
Mr. Chairman.
Yes, sir.
We've got a few days or more. I mean, could we make this decision next week? I mean, does that create, and you not move forward, you kind of still at this particular point, and then we make that decision one day next week, and does that create a problem? You don't have to negotiate anything right now. I think what Commissioner Hertzfeld is saying is she just needed a little more time to whatever guardrails, and then we could, because you're right now, you wouldn't have to negotiate if you're not retained, for sure. And I'm just trying to find a compromise here where, I'm comfortable with Professor. I'm comfortable with that, but I just also want Commissioner Hertzfeld's concerns addressed. And I'm just saying, it's a few days going to hurt either way.
But Commissioner, I'm not sure, Commissioner Starling, I'm not sure what I'm supposed to do between now and next Thursday, I guess, is the problem. If I've already had conversations with Austin, and presumably I'll meet his partner, the lawyer at Bradley, who has worked for the commission before. But I'm trying to go through in my mind how I have this conversation, or how any of us has the conversation, to give Commissioner Hertzfeld what she wants. And what she wants is not inherently unreasonable. It's just difficult to achieve under the guidelines she's setting forward. Because if I call Austin and say, are you willing to do this? He might be willing to cap, or he might be willing to put some guardrails on, and that would be okay. Or he might tell me to go find another lawyer to help you, and then that would require more time and looking for other people. So I'm just trying to have a sense of what
I can tell you.
Okay.
Not to interrupt, but I don't know how difficult it would be to get you and Mr. McMullen and Chairman Delanis on the phone to say, hey, what can we do to work this out? I guess I'm not understanding why it's hard to do that, and I trust the chairman to have that conversation and to report back to us with a proposal. He's negotiated the other things that we've done, and I trust him to do it. I guess I just am having a hard time understanding why we can't get a law professor, a law partner, and the chair of the commission on the phone for a conversation about the terms of potential representation.
But then what if we come back and we think it's a good deal, and he's done his thing, and we're going to have this conversation next week again. That's my concern.
I think that's the point. I think I'd like to have that information and we can have that conversation and hopefully, you know, I mean, I've been supportive of this arrangement in the past. I think there's some skepticism here, but I've been very supportive. I made the motion the last time. It's not that I am trying to sabotage this in some way. That is not at all the case. I just would like this information done so we're not just kind of pushing forward. And I think the chairman probably understands where I'm at.
You know, the selection of a lawyer is a really important decision. And as chair, I would like this to be done by consensus because
Yeah, I would too.
You'll be reporting to everybody, and I want Ms. Hertzfeld to be happy to call you up or Mr. McMullen or Mr. Odebiku or whatever. So I guess I'm requesting if we can take some time maybe on Wednesday or if you can before that to talk to Mr. McMullen and, you know, put it to him and say, hey, you know, what can you do to give the commissioners some comfort here that this is not a runaway freight train that they're getting on, and leave it up to him, maybe go to the firm leaders and say, hey, this is a really big case and, you know, it's going to be a lot of public notoriety to handle it. What can we do?
Yeah, and I, you know, if Commissioner Hertzfeld is not comfortable, I agree. I think a consensus is a much better approach here. But let me also say that I understand the concern about cost, and I'm capping my cost, so I'm not talking for myself here. Right. But if I have to negotiate with the Bradley people, with Austin or whoever, someone else, there's a risk of creating a deal that's too tough, because then do I not feel comfortable calling them? And what if we get a memo that we have to deal with overnight? Do I really want to be constrained about that? So every time you put a constraint on a deal, you can't squeeze too hard. And I'm not squeezing myself because I'm already squeezed. No, but I'm talking about the people that are going to be working with me. I don't want to be in a position where I have to say, well, you know, they're a law firm. They have N different things to do. Are they going to put my work at the back of the queue, or are they going to put it at the front of the queue? And this has to be a good engagement for them. I've already agreed to a flat rate, even though, as I've said, my experience doesn't work out so well for me. I'm committed to this, and I've agreed to do it. But on behalf of the people who are going to be working with me and assisting me, I think, Commissioner Hertzfeld, I don't think we want to have, or that you want to have the commission too tight on its parameters. I don't want to be a second-class citizen when I call over there and say, I need a memo on something, or I need you, let's talk about this, or let's have a Zoom meeting and get together on this. This is an important issue. It's a very important issue, and I don't want to be in a position of squeezing them too hard.
I understand.
Do I want to squeeze them some? Yes. Everybody. That's okay. I've been squeezed. Other people can be squeezed. That's okay. But you want to keep it where it's kind of your lawyer is doing the squeezing rather than the commission doing the squeezing. And my concern now is that this is going to be, you know, it's like buying a car. You get a salesperson in there and you get a deal, and then you get a good deal, and then they say, let's see if I can sell it to my manager. And then you go and you talk to the manager, and the manager says, well, almost, but I'm going to have to shave you another $300 or $500. I want to avoid that. I really don't want to be in that position, and that's my concern. Am I going to stand here and kind of throw down a gauntlet? No, I'm not. I'm going to do what the commission wants to do. I'm just saying, be careful what you want, because what you get may not be what you want.
Right. I'm hopeful we can come up with something that will satisfy your concerns and satisfy Ms. Hertzfeld's concerns. And if we can't, then I guess we'll have to call a vote, but I'd rather not do that at this point because I would like to try to achieve a consensus.
That's fine. You know, as far as I'm concerned, I conclude that my representation
Right,
has
and
been
and we
concluded.
appreciate that. We absolutely do.
And so I've kind of done my work, and this was not pre-negotiated. And if you want me to continue, I've expressed an interest and a willingness to do it on the terms I've described,
Right.
and I will do the best I can. I've done these before. I remember years ago taking on a consulting role as a party before a Supreme Court of a different country, and then winding up having 3 times as much time in it as I thought I was going to have. Right. And, you know, I ate that a long time ago, but those kinds of experiences are out there. So there's some risk. I'm taking on some risk. I want to be able to call upon, I can't do this all. I want to be able to call upon people. And, you know, if you all want to see what the final terms are, what the cap is, or what the parameters are, or maybe, Ms. Hertzfeld, how I plan to manage this, maybe with, you know, monthly bills or rather than quarterly bills or something like that. There are a lot of different ways, and I'd like your input about how you think I should manage it. I agree with you, there's a management issue, but the question is how to implement that.
Right. And
how
that,
to do it in a fiscally responsible way, but where the product is not compromised.
Right.
And I feel comfortable with this because I'm not negotiating for my own fees.
No, I understand.
We're talking about the fees of the people who are going to be assisting me and whom I want to be able to call on, and I don't want to be at the bottom of their queue.
no, I completely understand. A couple days also would give me a chance to go to Mr. Roberts and say exactly what did we do with Bill Koch, and then we can at least follow that game plan to some degree and be able to address Commissioner Hertzfeld's that way, because we all did approve that arrangement, and you know, maybe we can do better this time, but I at least want to look at that as a baseline.
And let me just say, I completely agree with your instincts, Mr. Chair, to try to get consensus. And clearly, Commissioner Hertzfeld feels strongly about this, and I think she should be accommodated. So what can I say? At some point, you all may have to make some kind of choices, and then you'll have to make some choices. I think that day isn't here today, and if we push this off to Wednesday, I can't really get back to this until Wednesday. If we push this off to Wednesday, you have a Thursday meeting, a conference call that we might have with Austin and maybe other folks at Bradley, because they may have to run some traps too.
Right.
They have their own leadership structure at their law firm that may not allow them to cap their fees or to put on a kind of set of constraints. And I don't know that we've had that arrangement with them before. I just don't know. If Mr. Roberts is able to look to see what happened in the past with the Bradley relationship with Dean Koch, then I think that would be some history. But in any event, as long as this doesn't go past a week, you know, the end of this week, Thursday, I think that Commissioner Starling has said this okay. I'm ready to go along with that. It really isn't going to be a lengthy period of time. My concern is that time is marching. Right. We have some obligations to do, and until, you know, if I knew that I was it, I would do the work. But frankly, I just can't do that. I'm not going to do that. So I'm just going to push the pause button until Wednesday at least, and that means that there's going to be a lot more kind of midnight oil that's going to have to be burned, and you know, I'll do what I can. I just would prefer to feel free to just go ahead and read the Cooper memorandum, read more stuff, and get started on it. But if that's not going to be the will of the commission, if Commissioner Hertzfeld doesn't want to go along, I'll go along. I'll go along.
Yes, Commissioner Davis.
Commissioner Hertzfeld, question. So your biggest concern is just making sure the guardrails of the financial piece is your biggest concern, yes or no?
I don't know that it's a yes or no. I think that it's complicated. Hiring a lawyer is chairman, sorry, I'm so loud, you can hear me without the microphone. You know, it's a big decision hiring a lawyer, and I don't have concerns about these lawyers. I have concerns about bills coming that are very shocking and expensive, and making sure that, you know, we are being good stewards. And I think that there are a lot of ways that lawyers can work these things out, and people are creative to do it. And I would just like to hear a little bit more of a proposal, as opposed to, you know, there's a $25,000 flat fee plus whatever Bradley's going to charge. So that's what I would like. I think I've expressed it now a whole lot. I think we've kind of talked about it ad nauseum.
Well, like I said, my issue is that, and the reason I was asking for clarity, because for this particular reason, because you want him to negotiate and then have the conversation so you can get your questions answered, and we still need a counsel.
So I think what you're saying is actually two different things. And I want to be clear, this isn't just my concern or me trying to be obstructionist, right? I mean, this is, you know, I'm a representative of the taxpayers of Davidson County, just like the rest of you. So this isn't something personal, because personally I know these lawyers. So
Well,
this
that's my whole point. My issue is that to be good stewards, as fiscally responsible, as well as getting the right representation for us here as representatives of the taxpayers by way of making sure the elections run correctly, we need to, I'm just saying, my question is that he wants to make sure that he's in a position to be able to do these things as much as you're going to get all the answers you want. So the question I'm having, where I'm driving this to, is that what do you feel comfortable with that we could decide on today where he can move forward with the chairman to get those answers to you?
I think I said I am not comfortable moving forward today. And if we move forward today, I'll be withdrawing my support for this legal arrangement.
I'm not saying, well, I think you're missing the interpretation of what I'm trying to get to. I'm not saying we have to say up or down to McMullen or anybody else. I'm talking about, I think what his concern's always been was that what can he do, because he's done his part for right now. We agreed to a term, to a contract with him. And so if he's going to move forward, that's like you're a lawyer and you've been paid for a certain thing. Now someone wants you to do something else. And they said, well, I want you to do it, but we're not going to have we're not going to have anything in paper. But would you do it for us? I mean, that's what he's saying here. I think if I'm not mistaken.
I'm not asking him to do that. What I'm saying is, I think I've said it a lot of times, and I just don't know how to say it anymore. And I think we have to make a decision on what we're doing today. I think the people have been here for hours and hours and hours. We've been on this retention of counsel issue now for many, many hours, or many, many minutes at the very least, for a very long time. And I have my position, and if you all want to vote and take your position, then, you've got the votes and you can go ahead and do that. But that's where I'm at.
Just for my own guidance, Commissioner, what advice would you, if you were counseling me, what would you counsel me in terms of doing work on kind of shaping up the issues that the commission has to deal with according to the Metro legal issues that were presented by Director Cooper? Would you want me to hold off until next Thursday, or would you want me to begin to talk to people about getting started? What's your timing in terms of kind of getting started on this project and not having time eat us up at the end? That's the very practical question that I have.
And I'm not trying to micromanage this situation. We're hiring counsel to do that for a reason. The question here is whether we are hiring counsel today. My recommendation is that we let the chair negotiate this issue and come back to us with a report so we can vote on it at our next meeting, which will be in a matter of days. We no longer have a deadline for court that is Thursday or Wednesday as it was before. It's moved. So there's not an urgency that we have to have this issue addressed exactly today. So I am putting my faith in the chair to negotiate this issue and figure it out. He's a good lawyer. He can handle this. Let him figure it out, bring it back to us. I'm sure I'll have a couple of questions, but you understand my concerns. I'm sure that the chair will address them, and then we'll move forward.
But again, from my point of view, I'm looking at this in terms of my tasking.
Professor Blumstein, I'm not asking you to do any work if you haven't been retained to do it. I'm not asking you to do work that you haven't been retained to do.
And what's the timetable at the back end in terms of the commission? When must you all decide whether to put this on the ballot or not?
There's not a specific time frame that we have to meet. Once the signatures are verified, they go to the clerk. The clerk will then instruct the commission to put an election before the people. The commission will then decide what date that election will be. At a minimum, it's 75 days from the date that the commission votes to put it before the people.
So we can extend that at the back end, is what you're saying?
You can, it automatically has to be extended from the point that the commission votes to put it on the ballot. That's when the clock starts running 75 days.
Okay. Well, if we have flexibility at the back end, then my concerns are a little bit mitigated, right? Because I have a little more time. What I worry about is there's a fixed date, and I'm losing almost a week here.
Right.
But if I'm not losing the week, then I think we have a different scenario. I just don't want to be told we need to have by May 1 or by whatever, a particular date. We have to have all this worked up and to the commission and the commission to review it. I'd like some flexibility, and that's all I'm going to say, is that if this works out, but it works out on Thursday instead of today, that's fine, but please give me a little flexibility at the end of the day so that I'm not too time compressed at that point. I just can't do stuff the way I did years ago on the same kind of timetable. I can't stay up till midnight and so forth. And work on weekends and so forth. Now, I'm just not able to do that. But if you can give me some flexibility at the back end, then the time issue that concerns me and does concern me is abated somewhat, is reduced. So I'm prepared to live with this if you all will just give me a pass a little bit on not having to drop everything and a little more flexibility about my own time.
And this is, I think, something we all know. I mean, there is a limit to the flexibility because the proponents of this referendum measure want a decision before the budget is presented to Metro and before the budget is approved, because as a practical matter, then the argument will be you were trying to tax something retroactively rather than prospectively. So there is that issue. And, I don't know exactly what that date is, because once we make a decision, there's going to be courts involved and there are going to be arguments on TROs, et cetera. So I think this is more for the commissioners than Professor Blumstein. The time ticking is important, but hopefully we'll have something on Thursday. And Commissioner Hertzfeld, if you can give us any kind of hints right today about what type of limitations you would be satisfied with, that will help us in trying to satisfy your concerns.
And I will think of a few things, and I will give those to Mr. Roberts, so there's no issue with open meetings or open records, and I'll pass my thoughts on to Mr. Roberts for him to pass on to whoever needs them.
And then is my understanding the commission will meet next Thursday on this issue? Is that?
Let's consult our schedules.
I am available anytime except for 10 a.m.
So this is April 22nd?
Yes.
Okay.
I think under the circumstances, this is the right thing to do. As I said, I would prefer to have more flexibility and more time, but I can certainly adjust and will adjust, because I think consensus is important value here. At some point, there may not be consensus, I suppose, but I think it's worth working towards it, and it's worth working hard towards that if we can find that approach. So I will agree to this, and I won't go off and pout in my tent or anything. I'll just wait. I'll just wait. But I can't wait for a long time. And Commissioner Chairman Delanis, we can talk about getting together on a phone call on Wednesday. I think that should work okay, fine. And thank you all for hearing me out and letting me participate and being so receptive. I really appreciate all that. And I look forward to working. Hopefully, we'll work this out, and I will be working for you and with you, everybody, you is all, not just some. Thank you.
Okay. What's, Commissioner Starling, what's your schedule like on Thursday?
I'm open all day Thursday.
Okay. Commissioner Davis?
Needs to be made.
Okay. Davis,
Well, I
okay.
said except maybe 2 o'clock, from 2 to 3, I'll probably be busy.
Except 2 to 3, okay. Commissioner Evans, what's your schedule like on Thursday?
I can be flexible. I can move stuff around. I've got a couple things for internal.
Okay. And Ms. Hertzfeld, I forgot what you said.
I have a call at 10, but I can move it if
Okay.
I can move it.
No, okay. Professor Blumstein, what about you on Thursday?
Do you want me to be at this meeting?
I think we want to schedule it just in case.
Okay.
And we would be sure.
Yeah, the only thing I have is
first.
a good friend and colleague of mine is leaving Vanderbilt, and there's a little reception for him between 12 and 1. So I'd prefer, I mean, that's a social event. He's a good friend. He's leaving. I can avoid that, but if it can be not between, just leaving me enough time to get from the law school here, so say 1:30, probably 11:30 to 1:30, I can't do it. But anything other than that, I think I can.
3:30? 3:30, okay? 3:30. Okay.
Okay.
Fantastic.
Same time, same place here?
I think we'll be here. Will we be here?
I'll have to confirm.
We'll check.
Right.
We'll double check.
Okay, thank you.
Okay, thank you.
3:30 will be fine.
3:30. And then we'll let you know what location.
Okay. And then, Chairman, we'll have to talk.
Yes.
And I'll leave it to you, or do you want me to call Austin? How do you want?
Let me call you and we'll talk about how we approach him.
Fair enough.
Okay. All right, we've gone through items 1 through 4, and I believe we've agreed to defer item 5. That brings us to the AOE report. Is there anything?
Tricia did make a motion to move this to the next meeting. No one seconded, so can we go from there?
Oh,
Okay.
I had the motion.
Okay, all right.
Item number 4.
Yeah, so the motion to defer is made. Do we have a second?
Second.
All in favor, say aye.
Aye.
Any opposition? With no opposition, the motion carries. Thank you, Ms. Harrison. Appreciate it.
Mr. Chairman, I'll make a motion to move item agenda number 5, discussion and possible vote of placing referendum before voters to the next meeting.
Okay. Do we have a second? I thought that's what we just did, but.
We did retention of council.
Retention of council to the next meeting. That was the.
Oh, okay. All right. Then we have a motion pending. Do we have a second? This is to move item 5 to defer it and move it to the next meeting. I think am I right?
Yes, sir.
Basically, we're going to keep deferring this.
Until we're ready,
And you just want it on the agenda.
in
Okay.
case we need to
All right.
take a vote.
There's a second.
All right, we have a motion and a second. All in favor, say aye.
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 With no any opposition? No opposition, the motion carries. We've heard public comment, so that brings us, and we've also set the time and date of the next meeting, and we have the AOE report.
Mr. Chairman, the person normally responsible for our petitions is out of the office for a few days, but I've already contacted senior staff. They are ready to go first thing Monday morning to start the review.
Okay. All right, is there anything further anyone wants to discuss under the category of AOE report?
No, sir. I'd like to make a motion to adjourn.
All right, fantastic. Do we have a second? We have a motion and a second. All in favor, say aye.
Aye.
Aye. No, with
Mr.
no
Chairman,
opposition.
I know you adjourned, but I'd like to add some clarity to one of Commissioner Davis's questions earlier. He asked me what day I was there. I've had time to review my calendar, and I was traveling back from Memphis on Tuesday, and I was at the Election Commission on Wednesday.
Okay, all right.
Okay.
Okay, with that, we're adjourned.
Thank you.
Thank you very much, and thank you for the members of the public.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.